Hey yo, peace family. Welcome back to Flesh of the Gods.
Welcome to Flesh of the Gods.
Well, isn't this a nice surprise?
Today we'll be covering YNW Melly, closing statements from the last trial, as well as YNW BORTLEN, his pre-trial today, his little preliminary hearings. What up to everybody in the chat? I see you. Tack Clouds, Chant My Black is Golden, Brown Sugar Babe, Miss D56. What up though? I see y'all. Appreciate y'all joining. We're gonna start off with how it ended off on the last trial. Let's get it. Oh yeah, before we get to that, don't forget to hit that like button, hit that subscribe, tap in, share with a friend. Know what I'm talking about? Yeah, let's get it. Today we'll be covering YNW Melly.
I'm going to just declare a mistrial.
After considering all the facts, jurors in YNW Melly's double murder trial unable to come up with a unanimous decision Saturday. On Friday, they asked for cell phone records and told the judge they were deadlocked. Melly's defense team thanking the jury for their efforts throughout the trial, but adding they were expecting a different result.
We are somewhat disappointed that Melly is not walking out the door with us.
Melly, whose real name is Jamel Demmons, is accused of murdering Christopher Thomas Jr. and Anthony Williams in October of 2018. Surveillance video shows the group leaving a Fort Lauderdale recording studio that night, and prosecutors say Melly shot and killed Williams and Thomas soon after.
Jamel Demmons was sitting in the back seat of that Jeep, and he was the one that fired the fatal shots that killed Christopher Thomas and Anthony Williams.
Investigators believe Melly and another friend then drove the car to a secluded part of Miramar, where they are said to have staged a drive-by shooting to use as a cover story. But Melly's defense team has maintained there are major holes in the state's case, even bringing their own witness who said Melly learned about the murders at the same time as the rest of their friend group.
There's a lack of evidence, there is a conflict in the evidence, and the evidence itself, and the investigation itself stinks.
And the jury did have a chance to...
So it was a mistrial because the jury couldn't come to an agreement. So it was basically like a hung jury, which is crazy because don't that mean that he should be innocent? Shouldn't he get out of jail from that? I guess it's different with the way this murder trial set up out there. What up though, Aaron Adventuring? I see you. Appreciate you joining, family. Shout out to y'all. Okay, now Miss D56, it's football season. That's what's up. All right, we're gonna get into this Cortlen Henry hearing. Let's start off with that. Let's get it.
310643 CF10A.
This was aired earlier today.
I've got Mr. Griffiths, Ms. Collins present for the state, Mr. Haddad, Mr. Nascimento present for Mr. Henry. Ms. Nascimento, I know you got to run. See Judge Siegel. I set today and tomorrow for all pending motions. Let me put a couple things on the record, and then I'm happy to listen to any evidence, witnesses, or testimony each side wants to present. Just save your arguments to the end, and then when we get done with the evidentiary portion today, if we're going to continue on to tomorrow, that's fine. But it's my understanding that there was a global offer extended to Mr. Henry, so I'm going to put that on the record and have a quick conversation with him about it, but I'll do that after we get done with the evidence today and get the witnesses out of here. So in preparation for the hearings today and tomorrow, I read the following. Number one, the defendant's motion to suppress statements of Cortlen Henry that was electronically filed December 5th, 2023. I read the state's unopposed motion for relief from the trial order dated July 8th, 2024. That was electronically filed August 25th, 2025. I read state's memorandum of law in opposition to defendant's motion to suppress statements of Cortlen Henry, as well as the attachments contained therein, which are transcripts. I couldn't find this one filed on CMS, but I assume Mr. Haddad got a copy of it. I couldn't find a filed copy.
The audio copy evidence you should already have.
Right. I did listen to, on a thumb drive that was provided to me, 2 audio recordings. I guess I'll have to wait to hear from the witnesses to tell me who's on the audio recordings. but I did listen to them. One is labeled Exhibit A, one is labeled Exhibit C. They're both dated October 26, 2018. One of them was at 6:50 a.m. in the morning. The next one was at 7:36 in the morning. I don't think the grand total of both audios takes up an hour. In fact, I'm sure it doesn't. But I did listen to all of that. So I did also read all the authority that is cited therein, in all the defense pleadings and in all the state's pleadings. Again, to repeat myself, I will let each side present whatever evidence, witnesses, or testimony they would like to present. With regards to any of these pending motions, I'll just ask you to save your arguments till we're done with all of the evidence. And then I'll give you a ruling as to all of them. I know we're set for tomorrow at 9 o'clock, and I know we're likewise set for trial. In both cases, 9 o'clock next Wednesday, which is September the 10th. So that being said, State, whenever you are ready, you may proceed.
The state would call, on the motion to suppress, the state's going to call Detective Jordan Cox, Officer Jordan Cox.
Okay.
All right, my fault. I'm setting up a couple things. We got TiVo.
Once you reach it, but before you have a seat, if you can just stop and look at me, please. Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth. Please be seated.
And yeah, that was a fact real quick. YNW Melly did get some new lawyers. Let's see. I think I got a quick clip I could play about that real quick. I think might be the wrong one. Is it this one? I think so.
YNW Melly is changing lawyers amid his murder case that is scheduled for retrial in 2027. The reason is because someone on his legal team is also under criminal investigation by these same prosecutors, which he says is a conflict of interest. He is replacing them with a well-known hip-hop criminal defense attorney who previously represented Cardi B and Lil Nas X. Melly is charged with 2 counts of first-degree murder in connection with murders of his 2 childhood friends. His first trial on the murder charges ended with a hung jury in 2023. He faces the death penalty if convicted.
Yep, I think that same lawyer represented Lil Durk too, and YFN Lucci. I think it's the same one. I'll pull it up and make sure because I ain't looked at his picture yet, but I'm pretty sure that's the same one. All right, let's keep it rolling, family. Y'all don't forget to hit that like button.
And sir, once you are seated, if I can get you to scoot that chair forward as far as it'll go. You can adjust that microphone so it's pointed directly at your mouth. Can you please state your full name and spell your full name?
Jordan Cox, Jordancox.
Mr. Griffiths, you may inquire.
The court doesn't mind a question from the table instead of like they're just going to find that really nice over.
Not a problem.
Officer Cox, who do you work for now?
Boca Raton Police Department.
And how long have you worked for them?
Approximately 4 years.
I want to take you back to October 26th of 2018. Who were you working for back then?
Miramar Police Department.
And what were your duties back on October 26th of 2018?
Road Patrol.
That evening, that early morning rather, where were you working?
Where was I working?
Where? Yeah.
The city of Miramar.
Any sites in particular, any locations in particular?
No, I was on FTO, so I was kind of roaming around the entire city.
Did you have an occasion to be called over to the Miramar General Hospital?
I did.
And what brought you to that location?
The detail officer put over the radio that there was 2 victims that were shot at the hospital.
When you arrived on scene, what did you observe?
I observed the SUV parked underneath the emergency bay with bullet holes all over it, and there's a black male subject sitting on a bench.
Did you know who that black male subject was?
At the time, no.
Did you later identify or learn who he was?
Yes.
Who was that individual?
Cortlen Henry.
Did you see Mr. Henry in the courtroom today?
I do.
If you could identify him by some clothing that he's wearing?
That day?
No.
Or just
today.
now? Just now, yeah, based off him and his tattoos.
Okay, so do you see him in the form today?
I do.
Where do you think, if you could identify him?
He's wearing a red jumpsuit.
Does that record reflect identify Mr. Henry?
Okay, the record shall so reflect. You may proceed.
At any point in time, did you have a conversation with Mr. Henry?
I did.
And what did that conversation consist of?
Upon arrival, I pretty much asked him what had happened, what was going on. Based off, he looked like he was in distress sitting on the bench. So just trying to figure out what was going on.
What was going on? What was going on around you when you first started talking to him?
We had medical personnel coming out of the hospital, trying to extract the victims from the vehicle, get them inside, and apply aid to them.
Were there any other officers present?
Yes.
Do you know how many were present?
I don't recall.
Do you recall where they were? Like where they were standing?
The officers?
Yes.
I had my FTO next to me, Officer Luna, and Jessica Amengor. She was standing outside the emergency room.
Okay. So it was just you and Officer Detective Luna who were talking to Mr. Henry?
Yes.
How were you dressed? How were the both of you dressed?
Road patrol uniform, Miramar Police insignia.
If you could just briefly, what was your conversation with Mr. Henry?
I can refer to my report.
Yeah,
That's fine.
refresh your recollection.
Yes.
Go ahead and take a look. Oh, yeah.
Yeah, so based off the what I observed with the vehicle and the victims, pretty much asked them what had happened, what was going on, where did this occur, how did this occur, just to get basic general information to provide to the detectives that were going to come on scene.
And did he provide you that information?
Yes.
Did he tell you where approximately this incident, where the two individuals in the vehicle have been killed, occurred?
Yes.
What did you do with that information?
I provided to the detectives that are right on scene.
Approximately how long were you speaking with Mr. Henry?
I don't recall.
Long period of time, short period of time?
Approximately about an hour.
And the entire conversation, where did that take place?
In the outside emergency bay, and then he was either admitted. He was either admitted to a room, or they took him into a room, and we spoke to him in there as well.
And at what point did you, at any point in time, did you leave Mr. Henry?
I did.
When did you leave?
When I had finished talking to him.
Were there any other officers present when he left?
I would say another officer took my role and stayed with him when I left the room, yes.
And
Dang, my bad. Y'all didn't even say nothing. Had that been up there the whole time? I still got this picture up there. I mean, this video. Well, while we here, what up, Starfish and Coffee? Joni 4 in the building. I see you. Appreciate you. Cynthia Trop. I see you. Appreciate you. Miss D56. All right, I appreciate y'all. Let me move this thing out the way. My bad. All right, here we go.
do you know when the detectives arrived?
I don't.
At any point in time when you were with Mr. Henry, did you ever advise him that he was in custody or under arrest?
No, I didn't.
Okay, cross-examination.
Good morning.
Good morning.
You proceeded to the Miramar Hospital because of dispatch.
Yes, sir.
that was dispatched to all units. How many police cars ended up being there?
I don't recall. Good amount?
Fair amount, more than a few.
Yes.
Someone said it was like a whole Miramar Police Department response because it was a shooting. Would that be fair? Anybody on duty that night?
I wouldn't say everybody because there's a whole city to patrol. A good amount of units were there.
If you could give a guess, was it more than 10 policemen there?
I don't recall.
How many do you recall?
Again with the I don't recall, right back in the court process. It ain't court without the I don't recall.
I'm sorry?
How many do you recall?
Approximate?
Yeah,
When I arrived on scene, it was just about 3 or 4 units on scene.
3 or 4. By the time you left, how many were there?
Probably 10 to 12.
10 to 12. Okay. Now let me ask you this. When you arrived, you saw the Jeep Compass. It had a couple of people in it? Jeeps?
Correct.
Okay. And Mr. Henry was out in the car?
Correct.
You know, the police lady, excuse me, the person in charge of the emergency room had him sit on the bench awaiting the arrival of the police?
I don't recall.
Right. Nobody had extracted the body here, correct?
Not that I saw, no.
Was there an investigation into the cause of death ongoing at the time?
I don't recall.
Did you investigate the cause of death?
I did not.
You asked Mr. Henry what happened, correct?
Correct.
And he told you what?
That he and his buddies got shot at in Fort Lauderdale. They were leaving a party.
But didn't you say that he advised that an unknown vehicle drove by and fired multiple shots that he was driving? Is that what you reported?
Correct, on the highway.
Yeah. Okay. And you said he told you where it was, and your report notes that units responded to the area of I-75 and Miramar Parkway looking for evidence of the shooting. Units were unable to find any casings or shattered glass, correct?
Correct.
That's what time was that? Did you direct them to go to the area you were shooting?
I did not.
You know who did?
I do not.
He told you, when he told you the area you shooting, you noted it here, correct?
When you say that, I'm sorry, repeat?
Your report notes the area of the shooting. Does that come from something you heard from Mr. Henry? Does that come from a compilation of the other reports?
It's what Cortlen Henry advised to me.
Okay. Did you pass that on to the detectives or to anybody else?
I did.
You dispatched it over your
No,
radio?
no.
What?
I spoke to the detectives.
Okay. Did you tell anybody else this is where the scene was?
Not that I recall.
Did you go to the scene?
I did.
You did?
I did, yes.
Did you go look for evidence of the shooting?
I did.
Before the detectives arrived?
After they arrived.
Okay. Did you find anything?
I did not.
Did you report back to the detectives you didn't see anything?
Correct.
Who was with you when you were doing that?
Multiple Miramar police officers.
Okay. And the detectives hired you over at the hospital?
Correct.
They were not looking, correct?
Not that I recall.
Thank you very much.
Based on that, any redirect?
No, Your Honor.
All right, state is the witness excused. All right, sir, you missed that now. Thank you very much. While he's doing that, state, you may call your next witness.
Take a call. Steven Toyota.
Huh?
Toyota's coming in, you want to copy?
I have? Yeah. Good.
Y'all remember the mask?
Polo, please spell your first and last name. DANNY-POLO. Thank you, sir.
Danny Polo, the masked detective. We got him coming up a little later too. Danny Polo, the masked detective.
Sir, if I could have you come all the way up to the witness stand, please. Once you reach it, but before you have a seat, you can just stop and look at me, please. Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth.
I do.
Please be seated. Sir, once you're seated, if I get you to scoot that chair forward as far as it'll go. You can adjust that microphone so it's pointed directly at your mouth. Can you please state your full name and spell your full name?
Stephen Toyota, Stephen Toyota.
State your name, Clark.
Good morning. Capital Dynamics. It's a global investment firm.
And back in, when did you retire from the Miramar Police Department?
February of 2021.
And were you working with the Miramar Police Department back in October of 2018?
I was.
In what capacity?
Homicide detective.
And on that night, did you receive a call to respond to the Memorial Miramar Hospital?
It was the morning of the 26th.
7 a.m.
October 26, 2018 morning. Yes.
And what, if anything, was the call that you received?
I believe it was very generic. Couple of dead bodies at the hospital being dropped off by a friend. And just so you know, I don't get into great details when they call me out when I'm asleep because most of the time early information is not accurate anyway. So that's all I had is some semblance of what was going on when I headed to the hospital.
And you specifically do that. You don't know too much so that you can get there and perform your own
Yeah, exactly. Couple of dead.
And let me kind of ask you, at that point in time, what was your role with the Miramar Police Department? I know you were a homicide detective, but were you kind of stepping back a bit because you were getting ready to retire?
Yeah, kind of internally within our team. We know when people are about to retire, and we try not to put them in really important positions in homicide as they get close to retirement for reasons like this.
7 years later,
Yeah.
come back to court.
Yeah, retired. And so, but yeah, I was definitely taking a back seat on a lot of things. I think that my saying was, I don't want to interview the shooter. I don't want to find the gun.
Excellent.
I don't want to interview the shooter. I don't want to find the gun.
So what was your role when you arrived at the hospital that morning?
A team player. I wasn't the lead. Detective Moretti was. So whatever he needed,
And what, if anything, when you arrived? Well, was Detective Moretti already arrived when you arrived?
he was.
What, if anything, did he tell you when you arrived at the hospital?
I don't recall specifically.
Did he ask you at some point to drive someone who came to know as Cortlen Henry?
Yes.
What did he ask you to do with Cortlen Henry?
We were trying to locate the scene of the crime.
Why were you all trying to locate the scene of the crime?
Evidence, video, hard evidence, video, anything we could. So also, we want to make sure it's in our jurisdiction. That's like an important part. But no, we're just trying to determine where the crime occurred.
At the time when you drove with Cortlen Henry, was he a suspect in this case?
No, he's a victim.
You all at that point believed he was a victim of this drive-by shooting?
Yes.
So when Cortlen Henry got into your car, what kind of car were you all driving?
It would have been a detective car. I'm not sure if...
Unmarked?
Unmarked, yeah.
Would there be any cage in the back or anything like that?
No.
Do you recall where in the car he sat?
I want to say I believe he was in the front seat.
Next to you?
Yes.
What did Mr. Henry do with you in the vehicle?
He directed me to the location, and it seemed like it wasn't very forthcoming, and went back to the station. He was courteous. Wasn't, obviously I don't think he's cooperative in that situation, but
So there was no questioning back and forth between you and him?
no. Well, questioning is where's this location? Exactly. Yeah. Nothing about potential suspect or the investigative part. We're just trying to determine where it happened, what happened. It's very early on in the investigation.
So it was just a turn left, turn right, go straight?
And then this is where it's at. Okay.
Was he at any point in time put under arrest with you?
No.
Was he in your custody at that time?
No.
Was he at any point in time not free to leave? He had said, I'm done with this.
No, he's a witness. He can leave whenever he wants. Well, at the time, we believe he was a witness, so.
And so at that time, he was just there voluntarily telling you guys and showing you where this crime scene was?
Yes.
No further questions, Your Honor.
Okay, cross-examination, go ahead.
Thank you.
Where
Was
is
he
the
talking
evidence?
before he gave a statement to Bertrand and Moretti?
I don't know the timing of the statement he gave to Bertram Moretti, but if it was after I drove him around, then yeah, he was talking to me.
After?
No, I'm not sure. What was the timeline of his statement?
You had a crime scene, you said. You said you were investigating a crime.
Yes.
You said that on the record. What constituted a crime?
The 2 dead bodies?
Okay, so you formulated an opinion of crime that occurred. So you had 2 dead.
We were working homicide, yeah.
Yeah, homicide. You were called out for a homicide.
Yes.
You had a person who was not dead, Mr. Henry, correct?
Correct.
Who was in the vehicle, correct?
Correct.
You're trying to ascertain what happened.
Yes.
Do you know whether or not police officers had already looked for the scene based upon what had happened with the guy, where he told another police, the lady at the hospital or another person?
I'm sorry. Can you say that again?
Whether or not he, in their encounter with the first police person on scene, that he gave a location for the shooting that was already investigated.
I don't remember.
You don't remember?
I don't.
You weren't told anything about where it may have happened?
I may have been. I just don't recall.
All right. So what did Moretti tell you? Take him and see if you can find something?
Yeah, he was, even if, and I don't recall specifically, but even if somebody thought they were, what the crime scene was based on what he had told them, we're still going to do a drive-by in person with him.
So you wanted to go back and look to see for the scene,
Try to find the exact location of the scene.
and you drove him there.
Yes.
That was at the direction of Moretti
Uh,
or Bertrand?
it's kind of a gray area at the direction. We work as a team, so yeah, it would have been Moretti is the lead detective.
You weren't the guy in charge, Moretti was.
Correct.
Because you were getting ready to retire.
That was the plan, yeah.
Yeah. So Moretti said, hey, I want you to take this guy and go see if you can find out where this happened.
Yep. Is that a question?
Huh?
Was that a question?
Yeah.
Yeah. Yes.
Yeah. Okay, and so Moretti directed him to you.
What do you mean by that? Directed him to me.
How did you get into the police car? You said to him, come on in the car?
I believe it was mutually, it was discussed that he's going to show us the location of the crime.
This guy knows where the shooting happened. Take him and look for it, correct?
Sounds about right, yeah.
Yeah. Well, who was you with, Moretti and Bertrand?
Not sure.
Where was he when you first encountered him?
I met him at the hospital.
Whereabouts in the hospital?
I don't remember.
Did you make any notes of where he was? You ever have that written down, did you?
I do not.
Okay, so you put him in the police car and you drove him somewhere, correct?
Yes.
What conversations did you have with him? Do you recall any of them?
I don't. I'd have to listen to the recording.
You didn't record them?
Actually, I'm not even sure if it was recorded or not.
Okay, you were a homicide detective, correct? You were called out to a homicide, so you passed on to somebody else. You got an eyewitness to a homicide, and you don't recall whether you asked him any questions or not?
I'm sure I did talk to him. I just don't recall. If there was a recording of it, it'd be easier for me to reflect on that, but I can't tell you exactly what we talked about, other than we're trying to determine the location of the crime.
To try to determine what happened. Did you ask him for his version of what may have happened to cause the murder?
I don't know if I asked him directly, but I'm sure somebody had asked him, and it may have been relayed to me.
We don't have any notes of that?
No.
Okay. Did you say there's recordings of that?
I'm not positive.
Were you wearing a body cam?
No.
Miramar didn't get you in that?
No.
There's no body cams of any of this stuff, correct?
I don't know.
How long after this did you retire?
February 21, so 2.5 years?
All right. How long were you a homicide detective?
18 years.
After driving with Mr. Henry to the scene, to have gone through this, there was no scene. Did you have suspicions about his involvement?
Let's see. No, not as far as a suspect. Obviously, he's involved. He's there with the decedents. So we knew he was involved, but no, I think he was just being uncooperative. It's very common in my career that people aren't cooperative only because they don't want to get involved. So that's kind of the gist that I got from him.
You didn't want to get involved?
Yeah.
And you were trying to get him involved, of course, by asking him what happened, where it was, right? That's what a detective does, correct?
Yeah, we're trying to determine the location of the crime scene, yeah.
Okay. And you took him back from already in Cortlen, right?
I would have brought him back to somebody, yeah. I'm not sure who I saw
The
one.
road where you thought you might be in the welcome back.
Yes.
You didn't take him home.
No.
You didn't tell him you're free to go, call somebody, we'll let you go now.
Not that I recall.
Thank you.
State, may redirect.
No, Your Honor.
Okay, Detective, I actually have a question for you.
Sure.
Let's say you drove out to wherever you were going, and right before you got there, Mr. Henry had said to you, hey, you know what? I changed my mind. I don't want to talk to you. I don't want to talk to anyone. I would like to get out of the car right now. What would you have done?
Let him go.
State, based on my question, do you have any additional questions?
No, Your Honor.
Defense, based on my question, do you have any additional questions?
You would have just let him walk out. Do you know Meridian, Cortlen's intentions were?
No. I don't know their intentions. But no, under the circumstances, he used the word cooperating kind of in a gray area, but he was being courteous. He was somewhat cooperating, so he was free to leave at any time. He was free to leave at any time.
You guys, let me see. You got two dead bodies. You're investigating a person who drove them to the hospital. You have a person who drove to the hospital. He's free to walk away. You're not going to complete an investigation? That's what you told me.
Wait, yeah, I tried to complete an investigation, but he's free to walk away. He's not a suspect. He's not detained.
You want to find out what happened, right?
Of course we do, but we get lied to very frequently. So,
Don't you keep people there to finish investigating?
no, I wish we did, but no.
You recall what your conversations were with Moretti or Bertrand about him?
I do not.
Just, if he had been subject to any questioning by you, as an 18-year homicide detective, that you would have noted in your report, correct?
Yes.
So if at any point in time you had engaged in questioning with him or anything beyond just driving into the crime scene, you would have noted that in your report, correct?
Yes.
And that was not your role in this case, to question anybody, correct?
It was not.
You were, not to diminish your role, but like road patrol
Yeah.
officer.
No, I was there for support at that point in my career. I was not trying to get in the lead.
No further questions, Your Honor.
Yeah. How many police besides you and Bertrand and Moretti were there?
At the hospital?
Yeah.
I have no idea.
It was already a crime scene established there by the first people that arrived, correct?
I believe so, yeah.
Yeah, you had a big crime scene tape, everything else where the truck was. You had, what do you call those people who take pictures? Crime scene investigators there and everything?
Yeah.
They were all there. No question about it, correct?
When I showed up, I'm not sure they were all there yet. Because we're all getting called out.
Huh?
We're all getting called out, so
Called out the whole town, right?
I don't know who they called out. I mean,
You were all called, all the detectives were there. You know the crime scene people were there, correct?
I do not know if they were there at the time.
Isn't it the first thing that you do when you have a thing, something like that that's established a crime scene? And you have a person to take.
You mean a crime scene log?
Huh?
You mean a crime scene log?
Yeah.
Yeah, we normally do that. I don't know.
You know when it was done, correct?
No, I actually don't know for sure if it was or not.
Okay.
He is, Your Honor.
Thank you, Judge.
State called Detective Mark Moretti.
What is up with all these squirrel brain detectives? Like, do they know anything? Do they do anything? Like, how do they get paid this much money a year? Like, He's a squirrel brain. How, Sway?
Prosecutors say they have proven plenty that shows he needs to remain behind bars.
I think that he should be granted a bond at all.
As his family clung to one another for support inside a Fort Lauderdale courthouse, Jamel Demons, aka YNW Melly, was back in front of a judge on Friday, asking to be allowed out of jail as he awaits the beginning of his new double murder trial.
But at least give him an opportunity for bond because he is presumed innocent.
Melly faces 2 counts of first-degree murder for allegedly shooting and killing 2 of his friends back in 2018.
I'm going to just declare a mistrial.
His initial case ended in a mistrial in late July after jurors couldn't come to a unanimous verdict, a fact defense attorneys argued about in court Friday.
Certainly, since the jury could not reach a verdict, there was a reasonable doubt by whether it be 1 or 10 or 9 jurors on the charges.
One was a fan and lied during jury selection.
Right. That makes sense because if there's reasonable doubt, then that should be not guilty. I mean, that's the whole reason why they can't come to an agreement, because somebody believes there's reasonable doubt. But I guess they all got to come to the verdict. That's crazy though. That's insane. That's crazy.
On multiple occasions, and then hung the jury.
Now, as they get set to begin retrying the case and picking a new jury, Melly is asking to be allowed out on bond. Leandra Phillips, whose son, Chris Thomas Jr., was one of Melly's alleged victims, told the judge she does not want to see him set free.
Innocent until proven guilty, but these are some serious accusations against him. So, and I understand he has money and I don't want anything, nothing to happen to me or my family.
And so all this time he been locked up, even after the mistrial, even after them not presenting any evidence, even after the prosecutor getting removed from the case, which I gotta grab a clip of that too. They still don't offer him no bond. But then what about this dude who was out on murder? I'm just a quick minute clip of how different it is for other people, and then we'll get back to the case.
A jury listened to a week of testimony in the murder trial of 20-year-old James Sotelo. In March of 2021, he gunned down 17-year-old Corey Thompson. You had to look at him every single day of the trial.
It took a large amount of patience, because you can feel your body just shaking with anger, but you knew you had to be patient so you don't have to go through that retrial all over again.
Sotelo took the stand and claimed he shot Corey because he attacked him in his sleep.
Of course, that's not true, because every gunshot that he had was sustained from the back. 11 of them.
Did he ever show any remorse?
Never, not once.
He never is going to take accountability for what he did. He never cared. He's never going to care. He just cares for himself. It's beyond selfish.
It only took the jury 4 hours to find Sotelo guilty.
That was a relief for us to know that, okay, at least he would take some punishment for what happened.
The trial was in the 232nd Judge Josh Hill's court. In Breaking Bond Reports, we told you how Judge Hill lowered Sotelo's bond amount twice.
To get out and continue to commit a crime. Again, he was caught with a gun, and you are just on bond for murdering somebody with a gun. It's terrible.
It was Judge Hill, not the jury, who sentenced Sotelo to 40 years.
I learned that most families don't actually get to have the moment we had today, and I'm very appreciative we were actually able to get a small piece of justice versus what other families can never see in their life.
It's better than nothing. I mean, for us, a life sentence would have been better, because that's where we're sentenced to.
Miss D, not other people. Yeah, other people. I ain't saying no types, just other people, just other. Just other.
Kids, but before you have a seat, you can just stop at what they need. Swear to tell the truth, whole truth, nothing but the truth.
I do.
So once you're seated, if I get you to scoot that chair forward as far as it will go, we can adjust that microphone so it's pointed directly around. Please state your full name and spell your full name.
Mark Moretti, M-A-R-K, M-O-R-E-T-T-I.
Thank you, Judge. Detective Moretti, where are you currently employed?
Employed with the Office of National Drug Control Policy through one of their initiatives called HIDA. It's a federal agency.
And what is HIDA stand for?
High Intensity Drug Trafficking Area.
And how long have you been with HIDA?
Since January.
Prior to January, where were you employed?
City of Miramar.
In what capacity?
Homicide detective.
How long were you a homicide detective in the city of Miramar?
Almost 10 years.
And how long were you with the city of Miramar total?
22 years.
And prior to your involvement with the city of Miramar, did you have any other law enforcement or military training?
Yes, I was with the Village of Pinecrest Police Department from 1998 until 2003. Prior to that, I was in the Air Force, 1991 till 1998. Then the Coast Guard Reserves from 2003 until 2017. Served as well as listed as well as a commissioned officer.
So, well over 20 years of law enforcement experience at the time of this investigation.
Yes.
And now, on October 26th of 2018, were you still working in your capacity as a homicide detective in the city of Miramar?
Yes.
What is the call that you received that night?
I was
When I say night, dark out, early morning hours.
I was called to respond to Memorial Miramar Hospital reference a double homicide. Two individuals were inside of a vehicle that were apparently victims of a gunshot.
And did you yourself arrive at the hospital?
Yes.
What, if anything, were you told when you arrived at the hospital?
I believe when I got on scene, I made contact with the supervisor, then later got in contact with Detective Bertrand because it was his week to be on call, so he was technically the lead. He called me out because he was soon to retire in less than a year, and he did not want to pick up another case. And so I, agreed to come out and help him.
And when you arrived on scene, did anyone kind of brief you as to what was going on?
The on-scene supervisor briefed me. Then once I got with Detective Bertrand, he briefed me on what he had at that point.
And what were you told was going on at that point?
An individual arrived in the entrance to the emergency room. It was a gray Jeep. The gray Jeep was still there. There was two victims. Both died of multiple gunshot wounds. Then they were later transferred to inside the ER. I believe that's where they were officially pronounced deceased, was inside the ER. The vehicle was still there. It was secured so no one can go in or out of it. Nothing could be touched like any other crime scene, because that's all we had at that point. That was technically our crime scene, even though we didn't know where this incident had occurred. We just knew that this vehicle came to ER with two dead bodies.
Now, this individual who came to the ER with two dead bodies, who was that person?
It was Cortlen Henry.
And do you see that person in the courtroom today?
Yes.
Can you identify him by an article of clothing and his location?
Red jumpsuit sitting next to Mr. Haddad.
Does the record reflect the inquiry identification presented by this witness?
The record shall so reflect. You may proceed.
How did you first come into contact with Mr. Henry?
He was in a treatment room. He was laying in a bed, wasn't handcuffed, wasn't under arrest. He, as far as we knew, he was technically a victim and the only surviving witness of a double homicide.
So when you walked in to speak to him, how did you introduce yourself?
It was recorded. I think I just gave my first name or said detective. I had to listen to the recording, but I had a polo shirt, regular slacks on, gun on my side, ID, badge.
You stated he was in the hospital room unrestrained. Was there anyone guarding the door to the room or anything like that?
the best of my recollection at this time, I don't think there was anyone guarding the room. I mean, there was a lot of police presence there that day. There was probably half the west side was over there. So.
Now, when I say guarding the room, as far as you were concerned, he was free to leave that hospital.
He was just as witness. We didn't have anything to. We couldn't detain him. We couldn't compel him to talk. If he didn't want to talk to us, we couldn't compel him. He was just a witness at that point, a victim.
And the judge has already listened to it, has already evidenced that statement. What was his demeanor like during that statement?
It was I would say a cordial conversation. You know, he was upset. His friends were just murdered in front of him. You know, but there was no hostilities, no arguing back and forth. No profanities or anything like that.
At that time in your investigation, was he considered a victim of this crime?
Technically, he was a victim because he was shot at.
And so was your questioning at that point in time not for incriminating information, but more of how did you end up in the hospital with 2 dead bodies in your car?
But the biggest issue is we did not know where this crime occurred. When it initially started off, we didn't even think that this even occurred in our city. And we didn't have a crime scene. What we were being told of where this occurred, we received no phone calls of shots being fired. There was no spent casings, no glass on the road. There was no indication that any crime occurred anywhere in Miramar that day.
And that's why, at the conclusion of your statement, Mr. Henry, you asked him if you would be willing to actually direct one of your officers, to where it happened, because from the location information he had given to you all at that point, it wasn't matching up.
No. Even in his statement, he says, "I'm not from here. I'm not familiar with there." So we gave him the benefit of the doubt. Like, okay, people get lost all the time. They might think they're on Miramar Parkway, but actually on Pembroke Road or Pines Boulevard. It's understandable. So he said, "You know what? Just ride with Detective Toyota and show him where it happened."
And did he say, "Sure, I'd be happy to do this"?
I don't know his exact words, but he didn't object. He wasn't in handcuffs. And it was an unmarked police unit, not a cage in the back of that car. So
if he had said, "No, I don't want to do that," what would you have done?
there's nothing we could have done.
Throughout your statement with Mr. Henry, did he ever say, "I don't want to speak to you"?
He never invoked his Fifth Amendment rights.
Even outside of invoking his rights, did he ever give you any indication that he did not want to speak to you? Did he say, "I don't want to do this right now"? Did he say, "I'm not comfortable"? Did he say, "Can we do this later"?
No. I mean, every question we asked, he answered. Might not have been the most truthful, but he answered every question.
And after he did this drive-by, was that kind of the end of your interaction with him at that point?
At that point, yes, ma'am.
Now, after that drive-by, did you then go speak with Mr. Henry at another point in time?
I'm sorry, can you say that again?
After that initial statement with him at the hospital, did you then speak to Mr. Henry at any other time?
When he was arrested in Houston, we did fly down to Houston to try to speak with him there, but he wouldn't speak with us then. He definitely invoked his right there.
Let the record reflect the importance of our jury, presented, members.
Today's discussions centered around the fact that the lead prosecutor from that initial case can no longer be on the case. She has been removed. So 3 other prosecutors are now taking over. Today, Melly watched on in his red jail jumpsuit as attorneys for the state and his defense team went back and forth about when this trial should officially begin. The defense argued that that it should be restarting soon, and following rules about allowing for a speedy trial. The state, though, is asking the judge to give them time to allow the new prosecutors to get familiar with the case they are now in charge of trying.
This is an accusation that could carry the death sentence of a defendant who hasn't been proved guilty because they haven't met their burden, and we don't think he's guilty.
We just got this case 48 hours ago. I mean, we know nothing. And in order to appropriately represent the state
and we'll still be at a disadvantage. If Ms. Bradley had this case for 5 years, she's lived it. We will still be at a disadvantage.
So at the end of all of that, the decision was made by the judge. They're going to be starting the very first part of jury selection tomorrow. Between tomorrow and Thursday, they're going to bring in 100.
That was evidence showed that was a lie. They still ain't started court yet. All right, let's keep it rolling.
And not at that point in time, he was a suspect, wasn't for arrest.
Correct.
Nothing further, Your Honor.
Okay, cross-examination, go ahead.
So now they're gonna get to the cross. This one and get a little bit interesting.
Good morning, sir.
Let's see how full of shit this squirrel brain detective is.
Lieutenant, the car was secured. I'd have to refer to the crime scene photos, but I believe they did put crime scene tape up around the vehicle. I'd have to look at the photos.
All right. Was crime scene investigators there from your department?
Yes,
They were already starting their work?
I believe so.
What time did you arrive?
About 6 o'clock.
In the morning?
Yes, sir.
And how long Mr. Henry been there?
I believe he got there, at 4:35?
So that's an hour and a half. How many cops were there?
You would have to look at the crime scene log, but there was a significant amount.
What do you mean by significant?
Well, it is.
In Washington right now?
I don't think that many. The only truly way to answer that question is look at the crime scene log to see who was there. I don't want to give you a number and be wrong, but
Let's say it was a significant police presence in the hospital, correct?
yes, sir.
You had 2 dead bodies, and you had an investigation going on. You had crime scene there. You had the vehicle involved.
Prosecutor.
Correct?
Yes, sir.
Mr. Henry was sitting down in the hospital.
He was in a room with a hospital bed. The heart rate monitor was on him. Basically, looked like he was receiving treatment.
What kind of treatment?
The hospital's protocol. You have to ask him why. He was just a victim of a shooting. I guess they wanted to check him out.
Was he shot?
He was shot at.
There was no physical injury to the there, correct?
No, sir.
Did anybody report any physical injuries?
No, sir.
He was in a hospital.
Yes, sir.
Was he handcuffed?
No, sir.
Okay. Now, you talked to the other detectives and you found out you don't have a crime scene to keep the time where it occurred, correct?
Correct.
And you went to talk to Cortlen Henry, correct?
Yes, sir.
And you say this, you say cordially, if I may, and your first words to Henry, hey, how you doing, what's up, man, how you guys doing? You say, hey, my name is Detective Bertrand and this is Detective Moret. We're here to talk to you about what happened, okay? That was said, right?
Yes, sir.
Now, the police say to him, all right, listen, you need to be straight up and tell us where this happened. Okay? My understanding, you told these officers something, but the evidence doesn't show that it happened. Correct?
Who said that? Okay.
Correct?
Correct. I got the statement in front of me.
Third line down. Fifth line down. The evidence doesn't show it happened. You got to be straight up. Correct?
Yep, that's fine. Yeah, you're right, sir.
Yeah, the evidence doesn't show that happened. You're confronting him with the fact that he's misrepresented something to the police, correct?
Yeah, but-
So you're saying it doesn't add up, correct?
Correct.
You're confronting him. Now, that's obstruction of justice, isn't it?
No.
Yes, it is. Did you testify in the trial that you had enough to arrest him at that time? You testified to Mr. Alstein that at that time you had enough to arrest him. I can find the transcript.
I would like to see the full transcripts on that because I don't remember specifically saying that we had enough to arrest him at that time.
Yeah, okay.
At the hospital because we didn't even know if this crime even occurred in the hospital. So for you to come in here and say that, it sounds like you're trying to put words in my mouth again.
Okay, you give me false information according to you, right?
He is giving me false information. It is. It's a misdemeanor.
You've got two dead people and he's giving you false information. You confront them with the fact that he's giving you false information, correct?
Sir, I do not want to arrest on a homicide for a misdemeanor charge, and then we got the speedy trial issues.
You want to arrest for a misdemeanor. Okay. You want to arrest for something more important, correct?
Correct.
Yes. And you're telling him he's lying to you, correct?
Correct.
Okay. You're accusing him of committing a crime. And how many policemen were around?
In that room was just Detective Bertrand and I.
How many were out guarding the room, guarding the hospital, meandering around doing whatever you cops do?
I could not answer that question because I don't know who was where, was walking around.
Was there a dozen?
You would have to look at the crime scene log, sir.
You don't have any video of it, do you?
No, sir. There was video outside the hospital where when the bodies were brought in, but I think that there's no video inside the ER room for HIPAA reasons.
So after you tell him that, he continues to talk to you, correct?
Correct.
You continue talking about you need to know where the scene was, correct?
Yes.
And you direct him, you asked him to go with Bertrand, correct? Toyota.
Yes.
How did you ask him?
You'd have to refer to the statement.
No, I'm asking you. You tell me how you asked him.
Would he mind showing Detective Toyota where it occurred? You'd have to refer to the statement.
No, I'm asking you. You tell me how you asked him.
Would he mind showing Detective Toyota where it occurred?
You already know you lied about where it occurred.
Like I said in the direct examination, I said that sometimes people get confused. Miramar Parkway, Pembroke Road. So
You say that to him?
no, sir.
That was in your mind. Maybe he was confused.
Correct.
You were having him go with a detective for what?
To point out the location where
He already committed a crime by misrepresenting. Was he free to leave?
Well, if you looked into our statement, we even told him, listen, we don't care about the drugs. We don't care about any other crimes. We only care about the dead bodies. I am not concerned about a misdemeanor lying to me.
But that's part of homicide investigation where it happened, correct?
The people, but
lying to you about where it happened, that can feed your investigation.
sir, every single homicide investigation we had, people lie to us. It is a part of our job, day in and day out. People lie to us, and we understand
You
it.
let them all go, correct?
No, sir.
Okay.
But people lie. We understand it. We accept it. And people lie to us.
That's the fact. This is about the third, fourth time he done ran up on him. And Judge ain't saying nothing either. He just gonna let him run up on him like, hey, go ahead, boss. I guess they don't gotta ask out there.
For different reasons. We didn't know he lied to us because he was involved in this homicide. We just figured he lied because they were doing something and they didn't want to tell the police about it. That was kind of our understanding. But we didn't feel that this even happened in Miramar. Oh, of course. I mean, what investigator would not confront them when the facts don't add up? I'm sorry, sir. I'm sorry.
Yeah, you confronted him with the fact you thought he was lying, correct?
Correct.
Thank you. I'll let go of that. Thank you, sir.
Based on that, you redirect.
Detective Moretti,
He was just walking all around like he do that like a closing statement, like he was talking to the jury.
when you all are telling him the evidence doesn't show that happened, was that saying, we think you committed this crime, or was it saying, as you testified on direct, we can't find this crime scene, where is this crime scene?
Correct.
And when the defense counsel keeps saying, he lied, he lied, he lied, we all know he lied throughout that statement.
Mm-hmm.
But in your mind at that point in time, was it, this man is committing perjury by lying to me, or was it, as you said before, he doesn't know the city of Miramar, doesn't understand what road this is, and isn't able to properly tell me where this happened?
We were not thinking that he was involved in this crime whatsoever.
And in fact, at the end of that recording, didn't you all even offer to drive him home?
I'd have to refer back to the full statement, but
if that would refresh your recollection, I believe it is just about the last sentence there, say.
I mean, like I said, it was not a confrontational encounter. I don't know if I have the full statement here. Can I see your version? Okay, it says question was actually from. It was actually from Bertrand, and it says Hector offered him a ride home.
And is that something that in your practice you all would oftentimes do when people are not in custody?
We've never given a criminal a ride home, so.
No further questions, Your Honor.
Based on that, you recross.
I got to ask one other question. Based on that, you've never given a criminal a ride home?
Dang, you see, hold on. That's how they do it out there? He just smooth walked up there. He didn't ask the judge or nothing. He said, hold on, I got to ask one more question. Let me go ahead and make my way up here. The judge didn't say nothing. The judge didn't even look up.
You ever given?
No further questions, Your Honor.
Based on that, you recross.
I got to ask one other question. Based on that, you've never given a criminal a ride home? You ever given a suspect a ride home, build up evidence to make an arrest later when they were a suspect?
If I was concerned that they were a suspect of a homicide, I am by no means going to get into a car with them and drive them somewhere for my safety alone.
So you've never done it?
No,
Let me
sir.
ask you a question. This person that was just considered a victim, it's a gunshot resident from it, correct?
Correct.
That's what you always do to victims?
Well, we were just trying to figure the case out. He wasn't telling us the truth.
The case was you had accused him of something and he's a gunshot resident. What other criminal investigation did you do?
We do that all the time. No, DNA would not have been possible. But we do that in almost all cases, just to rule him out.
Rule him out as a suspect. Because he was a suspect at that time.
No, he was not a suspect at that time. We had no idea, no indication whatsoever. And even then, when we did the GSR, which there's two different types of GSR tests, the first one is just a presumptive test, and it's done after the initial test. And that just tells us if he handled a gun. That first test came back negative, which even corroborated in our mind a little bit more that he was not involved in any of this.
All right. You were doing investigative stuff, right?
Yes.
That's part of your protocol to take GSR?
Oh, we've done it many times with witnesses and stuff on case victims. That's nothing unusual.
What if they refuse?
Then we don't take it. We ask. The crime scene technician asked.
Okay. A crime scene technician went up to him, asked him for gunshot residence?
Yes, sir.
Test. Was that at your direction?
I did not direct it, no.
Bertrand?
I do not know.
You was under your presence?
I was there when it was done.
You were there?
I was there.
How many other detectives counseled?
I couldn't even answer that question. At least Hector and myself and Detective Bertrand.
So he was in the presence of these three?
Well, it is outside the scope, but over your objection, go ahead.
There was 3 or 4 policemen with him asking him to give him to let them touch his hands, correct?
Correct.
And he thinks he's free to leave?
I can't testify to what he was thinking, sir.
What were the conditions of what a normal person would think, surrounded by police? That he was free to leave?
Well, yeah, I'll sustain that one. I think that's the question I have. Any other questions?
No. Well, thank you, Judge.
Okay, state.
Yes, Your Honor.
Thank you, Your Honor.
Real quick, 5-minute restroom break real quick. We'll be in recess for 5 minutes.
You will read this for evidence, right?
Huh?
The audio, you will read that to evidence. You don't need to read that for evidence. Just before we let him go.
I'll do this on the record, but
Yes, indeed. I guess we did just witness another squirrel brain detective. Hot diggity dog. What up, no one? I see you. Appreciate you, family. Appreciate you joining. DTB in the building. What up? I see you. Appreciate you. Man, that's insane. They don't do nothing, right? Oh my gosh. How does this system work? How does this work? How do they get away with this?
Yeah, I will. That's why I was like, wait a second, you didn't.
How, Sway? That don't make no sense. Squirrel brain detective agent coming near you. Already near you, actually.
Yeah. Well, at this time, Your Honor, the state would move what has been already provided to Your Honor.
Let me go back on there.
He's already got it. That's labeled up there.
All right, let me go back on the record. This is State versus Cortlen Henry, 19-1871 CF10A and 23-10643 CF10A. I continue to have Ms. Collins, Mr. Griffiths present for the state. Mr. Haddad present for Mr. Henry, who continues to be present. State, yes.
As a formality, the state would move at this point what has been provided to Your Honor previously in reference to State's Exhibit 1. It's the two clips that Your Honor already talked about on your files that the state already discussed, that Your Honor reviewed by stipulation of the parties and had completely satisfied.
Defense, any objection? No. All right, without objection, Ms. Wilcox, we'll call this state's A for identification. It's going to be in evidence only for the purposes of this hearing. That's
Yes.
State's Exhibit 1.
I had talked to the state because I had got repeatedly that they might vote trying to stuff about doing arguments tomorrow. I've read
We
it.
have no objection to that. So.
That's fine.
And I may put them on,
That's fine.
but I can't talk on my good.
State, you have no other evidence or witnesses or testimony you want to present today.
No, Your Honor, just argument.
And Mr. Haddad, whatever evidence, witnesses, or testimony you want to present, you want me to do that tomorrow? All right, that's no problem.
I also, with the state motion, extreme stuff.
Oh,
You said, you know, like, I don't know what to call it.
we filed the state's motion for relief from the trial order.
Yeah, to file your motion in limine.
Correct. But I think we agree that that's moved because he doesn't intend to call.
The two witnesses. All right, I'll handle that when we do the arguments tomorrow.
Just so Your Honor knew it wasn't something that
Understood.
was heavily litigated.
Yeah, that's fine. So the only thing I'm going to press pause on the all pending motions, and again, we're going to resume tomorrow at 9 o'clock. That's the defense motion to suppress. I'll give you a ruling on the state's unopposed motion for relief from the trial order, as well as the state's motion in limine. But I'm going to let each side continue to present whatever evidence, witnesses, or testimony they'd like to do before that. So I'm going to pause on the evidentiary portion today. I do want to have a quick conversation with Mr. Henry. I'm going to put him under oath. Talk to him about the charges, make sure he understands the maximum possible penalties, make sure he understands the state offer.
I think that's something else the defense wants to speak to him about tonight.
Yeah. Well, I'm going to put it on the record right now.
They about to put it on record. Here we go, family. The life plus life plus life plus life plus life plus life plus 16 years, but we'll off settle out of court for 16 years if you just, and we'll take away the murders that we got you here for anyway. Everything we got you here for is murder, but we're gonna take away the murders and give you everything else. What? It's confusing. I know. I'm still confused too. Let's listen.
But he doesn't have to tell me what his answer is now, but I just want to make sure he has all the info. And what I'll tell you all, I'll be back here tomorrow, and then, you know, I'm going to tell Mr. Henry this as well, but for his benefit now, if he wants to resolve the cases by way of a negotiated plea, that's fine with me. And if he doesn't want to, that's fine with me too. But the one thing that I am going to change, if you need me to, I can put him on maybe Tuesday afternoon, the 9th. I'd rather just not do it. I'd rather know yes or no the day before, because there's a significant, number one, I don't want him to feel any pressure. But number two, I got 250 citizens coming in here Wednesday morning, and there's
Tuesday afternoon is fine, Your Honor.
Yeah. If need be.
I have a hearing at 3:30.
It's fee hearings, you know.
Yeah, so I don't really have to say.
But I'm going to be here, right? Okay. All right, so Mr. Henry, listen, I'm going to put you under oath and ask you some questions, okay? It's only going to be as it relates to the state's offer, and it's only as to make sure that you understand the state's offer and you understand the charges that you're facing here. We're not going to talk about anything else. So just listen to my questions and answer the questions, okay? Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth. Okay, you can put your hand down. Please state your full name. How old are you? How far did you go in school? Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? All right. How are you feeling this morning? Your head is clear? You understand what's going on? All right, so Mr. Henry, listen, you've got two cases. I'm going to go one at a time. In case number 19-1871 CF10A, right now, you're charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital felonies, which means it's a mandatory life sentence. If the jury convicts you of count 1 or count 2 as charged, that's life in Florida State Prison. I have no discretion. Count 3 and count 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty for each.
So they're trying to charge them with count 1 and count 2, which is the murders of both of them, right? But then they're trying to charge them with 3 and 4, which is accessory after the fact. How you gonna charge them with both?
Each of those is 30 years in Florida State Prison. Okay. Are accessory after the state prison. I have no discretion. Count 3 and count 4 are accessory after the fact to murder in the first degree. Those are count 1 CF10A. Right now, you're charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital felonies, which means it's a mandatory life sentence. If the jury convicts you of count 1 or count 2 as charged, that's life in Florida State Prison. I have no discretion. Count 3 and count 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty for each of those is 30 years in Florida State Prison. Okay?
Monkey shit.
In your other case, which is case number 23-10643 CF10A, you're charged as follows. Count 1 is tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. All right? As the maximum penalty. Count 2 is directing the activities of a criminal gang. That's a first degree felony punishable by life. So the maximum penalty there is also life in Florida State Prison. Count 5 is conspiracy to commit tampering. And again, as it's charged, that is also a life felony. The maximum penalty is life in Florida State Prison. And lastly, count 7 is unlawful use of a two-way communication device. As that's charged, the second degree felony. The maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing, Florida State Prison. Charged, that is also a life felony. The maximum penalty is life in Florida State Prison. And lastly, count 7 is unlawful use of a two-way communication device. As that's charged, the second degree felony. The maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing, the maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison. Do you understand the charges and the maximum possible penalty?
Hold your horses, family. Hold your horses. So this is the original offer. This is the original offer.
Life in Florida State Prison.
This is what he's facing.
It's unlawful use of the maximum penalty and in Florida State Prison. Count 5 is conspiracy to commit tampering. And again, as it's charged, that is also a life felony. The maximum penalty is life in Florida State Prison. And lastly, count 7 is unlawful use of a two-way communication device. As that's charged, the second degree felony. The maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing, the maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison. Do you understand the charges and the maximum possible penalties involved? Okay. So, Mr. Henry, the state is telling me that they're extending an offer to you, and the offer is as follows. In case number 19-1871 CF10A, they're going to null process or drop counts 1 and 2, both first-degree murder charges. Okay, and in exchange for that, as to counts 3 and 4, they're going to null process or drop counts 1 and 2, both first-degree murder charges. Okay, they're going to null process or drop counts 1 and 2, both first-degree murder charges. Okay, and in exchange for that, as to counts 3 and 4, in that case, the accessory after the fact to murder in the first degree, you're going to plead no contest to both of those. And as to the 4 counts in case number 2310643 CF10A, you're going to plead no contest to all 4 of those counts. And in exchange for all of that, the state is offering that I would adjudicate you guilty and sentence you to the bottom of your sentencing guidelines, which is 195.45 months, about 16, it's a shade over 16 years and 3 months, 16 years and 3 months. All of those sentences will run concurrently, that is at the same time with each other. I would give you credit for all the time that you have served.
So, instead of them 6 lives plus 75 years that y'all threatening me with and trying to put me in jail for, you want me to take a plea to something I'm innocent for and take 16 years? Come on now, man. Tell me this shit ain't fucked. That's some fucked up shit. Now, if they got some proof to show he did it, then prove he did it. But how y'all gonna say we gonna threaten you with 6 lives? If you lose, you gonna get 6 lives, 6 lifetimes plus 75 years. But if you want to take this plea, we let you out right now for the low price of 15 years and 365 days. Fuck out of here, man. This shit is crazy.
Understanding that you have a lot less credit time on the 23 case because it's a newer case. So that is what would be controlling. Whatever credit time you have on the 23 case, you can subtract that from the 100
I think he actually has more time on the 23 case than the 19 he's out of custody.
Oh, okay. Well, whichever case you have more time, less time in custody, that's what would happen. And you get the credit for all the time that you've served. And again, that sentence would be 16 years, a shade over 16 years, 3 months in Florida State Prison. I would have to order restitution. The state would tell me the amount of that restitution. That restitution would be joint and several with any of your other co-defendants. If any of the other co-defendants were convicted at trial or entered pleas. In other words, the restitution or anything else. So just listen to my questions and answer the questions, okay? Raise your right hand. You swear to tell the truth?
I'm sorry. I got to run that whole thing back right there real quick. Man, that is insane. That is insane. I just went back like 2 minutes or so, but man, I can't believe that. How you go from 6 lives? And you see the way, the way he looked at him, I see y'all. Oh man, hold on. Let's take a breather. Let me take a breath. That's insane, family.
Well, isn't this a nice surprise?
Truth, all truth, nothing but the truth. Okay, you can put your hand down. Please state your full name. Listen, you got 2 cases. I'm going to go one at a time. In case number 19-1871 CF10A, right now, you're charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital felonies, which means it's a mandatory life sentence. If a jury convicts you of count 1 or count 2 as charged, that's life in Florida State Prison. I have no discretion. Count 3 and count 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty for each of those is 30 years in Florida State Prison. Okay? In your other case, which is case number 2310643 CF10A, you're charged as follows. Count 1 is tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. All right? As the maximum penalty. Count 2 is directing the activities of a criminal gang. That's a first degree felony punishable by life. So the maximum penalty there is also life in Florida State Prison. Count 5 is conspiracy to commit tampering. And again, as it's charged, that is also a life felony. The maximum penalty is life in Florida State Prison. And lastly, count 7 is unlawful use of a two-way communication device. As that's charged, the second degree felony. The maximum penalty is 15 years in Florida State Prison.
So pretty much, the deal is, if we throw out all them murders and all that stuff, we just gonna charge you with having the unlawful use of cell phone, and we gonna give you this 15, 16 years, and we throw everything else out. We just gonna charge you with having a cell phone in jail.
So right now, as to all the charges that you're facing, the maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison.
Okay, I was wrong. It was 5 lives. 5 lives plus 75 years. I had to count it again.
Do you understand the charges and the maximum possible penalties involved? Okay. So, Mr. Henry, the state is telling me that they're extending an offer to you, and the offer is as follows. In case number 19-1871 CF10A, they're going to null process or drop counts 1 and 2, both first-degree murder charges. Okay? And in exchange for that, as to counts 3 and 4, in that case, the accessory after the fact to murder in the first degree, you're going to plead no contest to both of those. And as to the 4 counts in case number 23-10643 CF10A, you're going to plead no contest to all 4 of those counts. And in exchange for all of that, the state is offering that I would adjudicate you guilty and sentence you to the bottom of your sentencing guidelines, which is 195.45 months, about 16, it's a shade over 16 years and 3 months. 16 years and 3 months. All of those sentences will run concurrently, that is at the same time with each other. I would give you credit for all the time that you have served, understanding that you have a lot less credit time on the 23 case because it's a newer case. So that is what would be controlling. Whatever credit time you have on the 23 case, you can subtract that from the 100
I think he actually has more time on the 23 case than 19.
Oh, okay. Well, whichever case you have more time, less time in custody, that's what would happen. And you get the credit for all the time that you've served. And again, that sentence would be 16 years, a shade over 16 years, 3 months in Florida State Prison. I would have to order restitution. The state would tell me the amount of that restitution. That restitution would be joint and several with any of your other co-defendants. If any of your other co-defendants were convicted at trial or entered pleas. In other words, the restitution only has to be paid once, but each person's responsible for 100% of it. All right, but as soon as it's paid, it's paid. I would have to impose mandatory court costs in each case, and I would have to impose a mandatory cost of prosecution in each case, which is $100. So, Mr. Henry, do you understand the offer that the state is making to you? Okay, the 16 years, 3 months, and a shade more. So I'm going to pause on it at this point, Mr. Henry. It's going to give you some time, whether that be tonight or also over the weekend, to talk to your lawyers about it. Make sure they answer all your questions, talk to your family about it so you can make a decision as to what you want to do. Now, let me explain this to you, sir. I can't make the state make you an offer, and I can't make you accept any offer. I'm just the referee, okay? This is a business decision between you, your lawyers, and the state. And if you want to accept it and resolve both cases that way, that's fine with me. And if you want to have a trial in both cases, that's fine with me too. It doesn't matter to me in any way, shape, or form. But whether it be tomorrow, when I see you tomorrow, and then Ms. Wilcox, she already has tomorrow at 9 o'clock, that'll remain on. But I'll put them on both cases as well next Tuesday, which is September the 9th. Let's just call it 1:30 in the afternoon. September the 9th at 1:30 in the afternoon. We'll call it trial status in both cases. That's when we're gonna have to finish this conversation, Mr. Henry, and you're gonna have to tell me that either that you understand the offer that the state's making, that your lawyers have answered your questions about it, and then you're gonna have to tell me what your decision is, whether you want to accept the offer or whether you want to reject the offer. Mr. Henry, the one additional thing that I like to talk to people who are sitting in this situation that you're sitting in right now to have this conversation is as follows. The reason that I'm doing this is because I want the record to be clear what the state's offer was, and the record to be clear that you understood it and that you had enough time to talk to your lawyers about it. You had enough time to talk to your family about it. You weren't under any pressure to make a decision, whatever you thought was in your best interest. Because it goes kind of like this. And I'm sure your lawyers could speak to it better than I can. If you accept the state's offer, that's fine. And again, if you don't accept it, that's fine too. But if you don't accept it, and one of these trials doesn't go your way, and you end up with life in Florida State Prison, which is a mandatory sentence on a lot of these counts, usually people in that situation, then they'll file what's called a motion for post-conviction relief, and they'll say, hey, Judge, my lawyer never told me. I didn't know that I could resolve all this for 16 years and 3 months, and if they would have told me that, I would have done it. And now I'm sitting here with a life sentence. So that's the reason I'm having this conversation now, so the record can be crystal clear on that issue. If it doesn't go your way, that argument's not going to be available to you to come back and say, hey, my lawyers didn't tell me about this, or I didn't know about this, so that's why I'm talking to you about it now. So, Mr. Henry, do you have any questions for me about the maximum possible penalties involved, or what the state's offer is to you as we're talking about it right now? Okay. All right, so I'm going to...
The absence of evidence is not the evidence of absence.
What?
Man, that's crazy. So they will be airing tomorrow. I will be airing some of that. But I do got the closing statements from the last trial. I do want to play that. And I got a couple other things I want to play while we here. Appreciate y'all hanging out. Shout out to the stream sponsor, Chan Ma Black is Golden. She says, these people have no proof, but others go free. That's a fact. That's a fact. And matter of fact, I got some proof of that. Let's see. I got a clip part 2 of Corey Thompson.
Criminal justice system has been, Rossi, it's almost as if Harris County's criminal justice system has bent over backwards for James Sotelo. The mother of the teen he's charged with killing wants to know why.
A lot of people say it gets easier with time, but for us, I don't think so.
The passing of time doesn't mean April Wright is even close to seeing justice in the slaying of her 17-year-old son, Corey Thompson Jr. 20-year-old James Sotelo was out on bond when police say he killed Corey Thompson.
This is a kid who shot my son in the back more than 15 times.
Police say Sotelo also shot his own brother, but he survived. After 232nd Criminal District Court Judge Josh Hill lowered Sotelo's bond for murder to $100,000, he walked out of jail.
While he's out on bond for murder and aggravated assault with a deadly weapon, he picks up an unlawfully carrying a weapon, a gun charge in Montgomery County.
And that is what is bothering us the most, is that this kid has a blatant disrespect for the law, for the court that he's going through, and he's still allowed to go home and be with his family. My son was never allowed to come home, and this kid is still out in the community.
If you're on bond for murder and charged with having a firearm, a gun, that should be an automatic, you go back to jail and see what happens with those cases. But that's not happened. So now he's on bond in 2 different counties. And for me, it's a disaster waiting to happen.
Oh, absolutely. And I would love for Josh Hill to answer the question as to why this case has come through your court. This kid has constantly been allowed to break the law and break his bond, and you haven't done anything about it.
So,
breaking that bond. Crazy stuff right there, family. Crazy stuff, crazy stuff. All right, let's keep it on rolling. Appreciate y'all being here. Hit that like, hit that subscribe, tap in, share with a friend. You know what I'm talking about.
Thank you. And please have a seat.
Thank you.
Now we're gonna get into a little bit about Detective Danny Polo. Oh, matter of fact, I got a clip before that to bring in Danny Polo, because first they argued about it. Where's Danny Polo argue? I think it's this one. Okay. Danny Polo came in with the mask on. That's him up in the corner left, in the top left. Let's see the first argument, then we get to that.
Objection is was previously stated as you're objecting to this witness testifying wearing a mask. Based upon his testimony, I overruled the objection, and now you're suggesting you want to revisit that?
Yes, sir.
So go ahead and tell me, make your argument.
May I inquire from the witness?
Sure.
Sir, are you aware that your picture along with your family is on the internet as we sit here today?
Nope.
May I approach?
You may. Same thing you showed counsel Seibel?
Yes.
Thank you. Go ahead.
May I show you what is a picture of mask? That is you and your family?
Yes, sir.
And that's on your wife's Cash App?
Yes, sir.
Which is available to anyone who runs that? Because we just ran this morning.
I guess so. I did my best to keep things clean. I guess I missed that one.
We would object to him continuing to testify with his mask on based upon that as a public record.
This is nothing that this witness put on. It was something that was done by a family member that he was unaware of. So based on that, and the testimony is still truthful and accurate as to what he has done to protect his identity on that. So based on that particular item, I don't think that rises to that level.
Thank you. All right, Detective, can you step down for a second, just wait outside?
Yes, sir. Your Honor, I have a request.
Yes.
Can I briefly call my wife and make sure that she's close everything that I might have missed?
Sure.
Thank you, sir. Briefly call my wife and make sure that she's close everything that I might have missed.
Sure.
Thank you, sir.
And Judge, we just asked if to have defense counsel not to preserve that because that is something that it got out. There would be concerns for the safety of the witness on that. It's already been seen by the court and be described as such. To preserve it or anything else on that that could lead to safety issues for this witness would be very troubling.
We have no problem with that.
That's agreed. All right. So, like to hear what the witnesses finds out from his spouse. I guess my concern is, it's always something we're trying to balance things. The news crew has a right to be here and film what's going on in the courtroom. The defendant has a right of confrontation. Typically, it's face-to-face. But, it's not hard and fast. The witness indicates there's threats on his life, and he's worried about his security of his family. And it's a balancing of all those things. So I don't know where this came from or how it was obtained. I don't know how you got a hold of the picture in the first place. You're saying it's on a Cash App?
So yeah, all you have to do, her phone number is listed, and when you put her in Cash App, the picture comes up.
Cash App is what?
So Cash App is similar to Zelle, Venmo, so it's if I want to send you money, or better yet, if you want to send me money, you have a Cash App, you send it to either my phone number or to my email, whatever I have set up. And most people do have pictures there. It is open to the public. Cash App is not one of, with Venmo, you can actually make things private. Cash App does not. So everything you do on Cash App is in the public domain.
Yeah, it seems a little concerning and troubling if they'd be looking at the witness's wife and family with the intent to cause them some sort of harm or to intimidate them in any way.
Well, I resent that, first of all. We have a right to confront the accuser. They made a representation. It turns out to be incorrect. So, quite candidly, I resent any implication that we're trying to put anyone in danger. Quite to the contrary.
Thank you. We in recess. When you want to step out?
He said his wife out there with her picture on the Cash App. I wonder if she was bent over. What's she doing for the cat? No, I'm just playing. What's she out there? She out there doing it for the Cash App. Got her picture and everything. I wonder if she got the OnlyFans.
Detective Polo, what's happened is you're wearing a mask now. Defendants have objected to that.
Yes, sir.
And the state indicated that it's been done in other courtrooms and there's a project.
Hold on, we about to pull up YSL Polo since Polo want to be masked up.
For, I guess because of safety and security is the way I understand it. Specifically your safety and security.
Yes, sir.
Is that correct, madam?
Yes, sir.
So I want you to come in here. I want to take some testimony from you outside the presence of the jury just to verify all of this. So, Ms. Bradley, I want to inquire.
Detective Polo, how are you so employed?
With Broward County Sheriff's Office.
How long have you worked for Broward County Sheriff's Office?
Since 2015.
How long have you been assigned to the Strategic Investigations Division?
Since March of 2018.
In your time in the Strategic Investigations Division, or SAD, have you worked undercover operations?
Since that time and before.
And the undercover operations that you work, what type are they?
Majority of them are narcotics, firearms, violent crimes, gang-related investigations.
How many years did you spend specifically in the gang and organized crime section of the Strategic Investigations Division?
From March of 2018 till 3 weeks ago.
Have there been credible threats on your life?
Yes.
Is there currently a critical threat on your life?
Yes.
In terms of is there an amount of money assigned to the death of you that has been offered up?
Approximately $50,000.
In terms.
How the hell you know how much the hit is on you? Somebody told you it was a hit on you for $50,000?
Of your safety and security, why do you wear the mask for those reasons?
To protect my family. So I'm not walking around Broward County, Palm Beach County, Dade County, anywhere, and get ambushed by someone that might be looking for me. We've done cell phone warrants on multiple people in Broward County involved in the investigation where I got the threat. And outside of that investigation, there's photographs of deputies being sent around, people trying to figure out who I am and what I look like. And that's a kind of a concern for me. If it was just one person, I'd probably just write it off. But yeah, after 5 or 6 cell phones got downloaded and there was pictures of many deputies being sent around saying, "This is Danny Polo." I'm like, okay, these guys are actually looking for me.
And so, Detective Polo, with regards to the prior times you testified in court, did you testify earlier this month before the Honorable Judge Martin Fine?
Yes.
How were you attired?
I believe I was wearing this suit, probably.
And in terms of your face, how was that done?
Same mask.
Have you testified before the Honorable Judge Michael Usan in this courthouse?
Yes.
Was that in or around February and March of this year, 2023?
Yes.
And what case was that on?
That was the XXX Tentacion case.
And that was the death of that individual?
Yes.
How many times did you testify in that case?
It was twice.
How were you attired when you testified then?
Different suit, same mask.
And in terms of during that particular testimony, were individuals trying to call your cell phone and get in contact with you during the actual testimony?
Yeah, that happened.
And was this testimony live streamed as well?
It was live streamed.
Yeah. Thank you, Your Honor.
You have any questions?
Yes.
On this issue, go ahead.
Yes. What time did you get to the courthouse today and sit outside?
Just after 9 o'clock.
And were you wearing that mask?
No, sir.
In fact, you've been sitting out there for at least an hour unmasked as people were walking in and out, correct?
Correct.
No. No, he's sleeping.
Are you the only expert in dealing with gangs in DSI?
I believe I'm the only one that's testified as an expert at the Broward Sheriff's Office currently.
How about in the state of Florida? You know?
I'm sure there's other experts in the state of Florida.
And for the last hour, you've been right outside this courtroom where the doors are, correct?
Yes.
Unmasked.
Yes.
As people in this group, including myself, were walking in and out, correct?
Yes, sir.
You weren't concerned about your safety then?
No one knows who I was out there. And I was under the impression I wasn't going to be allowed to wear the mask. So I took that one on the chin.
I have no further questions.
Thank you. So, detective or deputy, I'm sorry, which is it?
Detective deputy.
Regarding, you're telling me that you have fear for your safety.
For my safety, but more for the safety of my family.
And that's if your face was broadcast.
Yes, sir.
And you're indicating now that there's intelligence from BSO that there's some type of bounty or price on your life.
I intercepted it on a court-authorized wiretap through the state of through Broward County. It was a wire authorized by Judge Siegel for the gang investigation. During that investigation, there was conversations about placing a bounty on my head, upwards of $50,000. And since then, we've, as I stated before, recovered several cell phones in that investigation, other narcotics investigations, firearms investigations, an investigation in South Carolina that was tied to Broward, where photographs of deputies were sent with my name attached to it. People trying to figure out who I am, what I look like.
Thank you, sir.
Thank you, sir.
You step down.
They're trying to find me. I have to hide, but I'm gonna sit in the hallway without no mask on. Right before I go testify. Oh shit, my bad, family. My bad for the cough. That was crazy. That was insane. Alright, let's keep it rolling. We're gonna get into some of the closing arguments. I got 2 different sets, but yeah, let's get into it.
Counsel, these are state attorneys. Ladies and gentlemen, I trust you had a nice lunch. This is the defense counsel's opportunity to address you. Please give Mr. Adelstein the courtesy and attention that you previously displayed to Ms. Bradley. Counsel, if you're ready, you may proceed.
Is he a principal or a shooter? That's what the state addressed you folks just a few moments ago before you went to lunch. And the reason they said that is because they don't even know. Otherwise, they would select either him being a principal or the one who caused the death of Williams and Thomas. It's that simple. Where is the fire? Was the message. They say it refers to guns. That's their interpretation. My interpretation, based upon the evidence, is where's the weed, the marijuana? That's the problem here, folks. They're interpreting it as opposed to calling these various people to tell you what they mean.
Hey, that's a fact right there. Who got that fire could mean a lot more than just a weapon. It can refer to weed as well. Who got that fire? You could say them shoes is fire. Fire could mean a whole lot of stuff.
They mentioned Frederick Gibbons, Frito Bang, Mariah Hamilton, Peasy, Patrick Deloach, Dontavius Withers.
Objection, Your Honor, Halliburton.
They opened the door. Stay. We don't have a burden. As the court told you in jury selection, the burden of proof is on the state. And the court told you during jury selection that this is a first-degree murder case, wherein the penalties are either life without the possibility of parole or death. You folks are going to determine this young man's fate. And they come in here and give you alternatives. They come in here and give you their interpretation when we don't have to do a darn thing. And that principle was so important that His Honor read you that instruction at the beginning when you were going through the process. That he just read it to you before the state got up and gave their opening closing statement. He told you that this young man has pled not guilty. That means you have to presume him innocent. That means that that presumption stays with him until and if the state of Florida can prove their case beyond and to the exclusion of every reasonable doubt. The judge goes on to tell you, and it's in your packet of jury instructions, that the defendant, YNW MELLY, is not required to present any evidence or prove anything. So it's nice that they're interpreting these things, but the bottom line is they don't even know. Because they've given you just 2 alternatives. Either he's the shooter or the principal. Make up your mind. Tell these folks what it is. Now, how do you go about doing this? Well, the judge gave you an instruction on that. you're to look at the evidence
The
that's
absence
been
of
presented
evidence
to
is
you.
not the evidence.
Remember,
What?
we don't have to do a thing. All we have to do is show up and behave. Now, I don't know if I behaved totally correct during the course of this trial. So, on behalf of us, let me apologize if I have, or we have, offended any of you. And I would ask you, I would plead with you, if I or any of the other individuals have done anything to irritate you, don't take it out on this young man. Still hold the burden of proof to this table. Now, why do they have the burden of proof? Because they are the state. They are the government. As we learned in this case, they have the police department of Miramar. They have the Broward Sheriff's Office. They have the DNA labs. They have experts, the FBI. They have everything at their disposal. And that's why our system of justice is different than anyone else in the world. We recognized a long time ago that when the government accuses somebody of a crime, they have the money, the resources, and the person power to attempt to prove to you all that a person has committed a crime beyond and to the exclusion of every reasonable doubt. Now, how do you go about doing it? And before I get into that, first of all, let me also thank you, because we have interrupted your lives for it seems like.
Speaking of interruptions, I got one real quick before that comment go. For those who missed it, Chan My Black is Golden, referring to that video that we showed with the other guy. He shot the black boy 13 times in the back, one in the arm, one in the head, and tried to say it was self-defense. One of the bullets went through the wall and shot his own brother, who survived. But that's crazy. And then out on bond like it's nothing, like nothing ever happened. Insane.
Months. And we have put a horrible burden on your personal lives, your family life, and what have you. And all of us applaud and thank you for your service. You folks have gone way beyond the call of duty. And I think we all recognize that. But how do we go about determining, and I shouldn't say how do you folks go about determining if the state of Florida has proved their case beyond and to the exclusion of every reasonable doubt? Well, the judge just gave you that instruction. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. Remembering, we just got to show up. And how does a reasonable doubt occur? Well, the judge has told you. It can come from the evidence itself, a conflict in the evidence, or a lack of evidence. You don't need all three of these areas. But I suggest to you folks.
And then, hold on, then they got the proof he did it, and he only got sentenced to 40 years. Probably be out in about 20, 25 years.
That we have a reasonable doubt from the evidence that has been presented, that there is a conflict in the evidence, and there's a lack of evidence. This is an unusual case, kind of like the medical examiners. The two medical examiners said it's unusual because normally you can't tell what shot occurred first, second, and third. And the chief medical examiner came in here, Dr. McDougall, I think, and told you it's only happened to her in her entire career, I think 2 or 3 times, that she could tell you which shot occurred first in this case. So, knowing that, let's look at what the state presented. But before we do that, we can agree upon a couple of things that are not in dispute. They said that Matt Melly is a talented music artist. We agree with that. At the age of 19, based upon the evidence, he was making more money than probably everybody in this courtroom, including us. Number two. Oh, I'm sorry. I apologize. You okay? Usually, the judge stop me immediately. Number two.
Look, he choked her up on that way. She was like, hold on. He was making how much? Hold on. I need some water. Hold on. I need some water. How much money he was making? More than everybody here? She had to choke up on that one. Hold on. Where is that?
He needs some milk.
Is that Cortlen Henry changed his clothes before he went to the hospital. That's what they said just 10 minutes ago. Number three, that there's absolutely no eyewitness that will implicate this young man to this crime, these crimes. Number four, they talk about premeditation. I suggest to you there is absolutely no evidence whatsoever to show premeditation. And the last one that we absolutely agree with, and they admit it, the Miramar Police Department lacks the training. Those aren't my words. That was Miss Bradley just an hour ago saying it. Not only did Miss Bradley say that, but Sergeant Williams also said they lacked the training in one of the worst investigations. That's why I pushed aside their reports. Now, the state produced over 100 exhibits sitting right here on the floor. Ms. Bradley made reference to some of them. They're all here. And I put them on this side of the podium because I suggest to you that this is a smoke screen. I suggest to you that this is open for anybody to interpret any way they want. When I say something sarcastic, you don't know if I'm serious or not. I can tell my colleague, I hate your guts, and it could be joking, and I am joking. And that's what this case is, and that's all this evidence is open for interpretation. That's not evidence proof beyond a reasonable doubt. Now I put on this side of the table really the evidence that means something. There's one other exhibit, but it's on.
Well, isn't this a nice surprise?
Now I put on this side of the table really the evidence that means something. There's one other exhibit, but it's on a little USB internet thing. And that is the video leaving the studio, showing the 2 cars and the 8 individuals that left. Sitting on this side of the table is the broken cell phone that Moretti could not tell you whose it was, and the 9807 phone that Melly uses, as other people do too. These are the 2 key pieces of evidence. These are what I suggest you focus in on, because you can take any one of these items, any one of these text messages, any one of these pinging on maps, and you still don't know what was said, what was meant, and more importantly, who said it. I leave my phone, and I'm sure you all, in the house, and my wife picks it up and sends a message. And it looks like it's coming from me. And sometimes she sends messages that I'm kind of shocked about. But you don't know. So let's put the 100+ exhibits to the side for a moment. The state called 26 witnesses. I think I counted. And I suggest...
I mean, I guess that's a good argument because it is possible that it could happen, but everybody know ain't nobody sending messages from nobody else's phone that you don't know about. If somebody else grab your phone, you be looking at it. What you doing with my phone? Let me see what you're doing. Let me see what you doing.
To you that you should look at 11 witnesses very carefully. And why do I say that? Because when you look at these 11 witnesses, you will find out that there's a conflict in the testimony, that there is a lack of testimony, and the third way is from the testimony itself. The first one that I would like to talk about well, before I talk about the first witness, I want you to remember one thing. On October 26th, that day of the shooting, we learned immediately that that Jeep was taken to a secure area. And it was searched for over 15 hours by 2 crime scene technicians. And you heard how they pulled out the evidence. They got some foam, some projectiles, I think a can, everything, and photographed the vehicle. Now, why is that important? Because that vehicle was searched. Are you okay? You want to take a break? That vehicle was searched again months later. But it didn't stop there. Because about 3 years later, miraculously, even though it was searched for hours by crime scene technicians, Sergeant Williams comes into the scene at the request of the state of Florida, this particular prosecutor right here, and miraculously he finds additional evidence, 2 projectiles and a bloodstain that obviously everyone else missed. That should tell you something about the quality of this investigation. That should give you a clue as to what's going on in this case. What happened was, once they got the surveillance tape of the individuals leaving the studio, they knew that Cortlen Henry, Williams, Thomas, and this young man got into the Jeep. It's shown on the video. In the Mitsubishi were Adrian Davis, Patrick DeLoach, Trevon Glass, and I'm missing one other. Withers, Dontavius Withers. And we know that on October 26th, when Moretti saw that surveillance, Cortlen Henry identified all of them. And in fact told them that he lives at this young man's house. I made a mistake. Jacoby Mills was in the car. It was Jacoby Mills, Adrian Davis, Trevon Glass, and Dontavius Withers. Okay? I can't keep the names straight. I'm lucky if I can remember my own name. That's why I haven't written it down. We know that Moretti identified all 8 people that left the studio on October 26th. We also know that Moretti knew where this young man lived, along with all the other 7 people that left the studio. We all know that, according to the state, Cortlen Henry lied to the police. And we also know, as the investigation progressed, that Cortlen Henry had blood matching the victim on his clothes. And he also had GSR, or gunshot residue, on his clothes. If that were true, and you saw the pictures of the Jeep, all bloody, blood all over the place, and we learned that you could spray and determine if there was blood right here on the carpet, even though you don't see it, why in the heck don't you get a search warrant for the house? Why in the heck don't you? Don't tell us we didn't know where he lived. Don't tell us it was months later, because they go into the car 4 years later and do this. So why don't you do it? Because Detective Moretti and the Marijuana Police Department, as everyone has said, lacks the experience and the training. We don't have to do a darn thing, folks. We don't have to do a thing. But let's go into the 11 witnesses now. The first one, and they mentioned it, George Bello, the manager, the head guy of the gun and tool mark unit of the entire Broward Sheriff's Office. And he tells you, after we get a great education of guns and projectiles and casings, we have to bring out the fact that can you tell or determine the distance between the shooter and the victim? Can you tell us that with all your experience? And what does he say? I can't do it unless I have the weapon, unless I have the ammunition, because ammunition, the weight of ammunition could change the distance. And you have to have the weapon in order to do that. He cannot even tell us if it was 1 gun, 2 guns, or more. He's honest. He tells you that without the weapon used, I cannot place the shooter to the victim, or victims in this case. Now, why is that important? Because a reasonable doubt can arise from a conflict in the testimony. If you believe George Bello, and I suggest you should, then he totally contradicts all the testimony of Sergeant Williams, who comes in here 4 and 5 years later and says, I can tell you where shooter 1 was, and I can tell you who the shooter is. You talk about a conflict in the testimony? It's one or the other. It can't be both. And he tells you, in addition to that, that the environment has to be considered. Now, Williams tells you he goes out to the scene some 4 or 5 years later and has no idea, nor did he even check the terrain, the environment on that particular morning hour. So you got to believe one or the other. You can't believe both of them because they are in direct conflict with each other. But let's go further. The next witness that you should consider is FBI agent Brendan Collins. He is an expert in tracking phones. He is not only an expert in Broward County, but he's an expert, and his team have been specially trained to map phones, not only in this country, but anywhere in the world if he's called upon. They brought him in. And what does he tell you? This expert. I cannot determine precisely the location of a phone. I cannot say 100% the phone is in, and you saw the band, it looks like a banana. He says, I think it's somewhere within this area, but I can't be 100% sure. He's candid with you. And he further tells you that the call detail records are limited. And I can't tell you who had the phone at any particular time. And most importantly, he tells you in making the mapping of the phones, the FBI, the special agents, do not use two items that are on the bill. That is the environment section, and he does not map out based upon the longitude and latitude. He goes to the cell towers and where they're bouncing off. And it could vary depending upon the strongest signal or how busy that network is. Well, he contradicts Williams, the one who comes up and tells you the phone is at this location here, this location here, this location here, at these particular times. It's one or the other, folks. I suggest to you there's another conflict in the testimony. The next witness I think you need to pay particular attention to and really get a flavor of what this case is all about is Felicia Holmes. Felicia Holmes tells you that the Miramar detectives, Moretti and his group, threatened her, bullied her daughter, told potential witnesses they were going to prison, told witnesses that they may never see their children again, told a witness that...
But yet they want to give them charges for tampering with witnesses. Ain't that witness tampering to do that type of stuff? Wouldn't that be witness tampering? That's insane.
That he was going to be deported even though he's been in this country since 5 years old. He was going to be deported to Haiti where they won't feed you. The place is, with all due respect, and excuse my language, but it was his language that he used, shit. This is the great detective. This is why this kid's sitting here. They have intimidated and threatened everybody. So I ask you, I beg you, to consider Felicia Holmes, because that tells you what's going on. When Moretti got that surveillance tape and realized this young man, this little kid, excuse me for calling him a kid, he was 19 at the time, was a rap star, making more money than he'll ever see in his entire career at 19. he got terminated. And he wanted to nail this kid. And what better way to move up the ranks, get some publicity, is to arrest a star. If they arrest Howard or myself, they go, who the hell is Addleston? Who the hell is Howard? That's the bottom line. So he just focused in, and everything was directed to get this kid. That's why he ignored everything. And that's why he intimidated and threatened anybody that said something different. So I ask you to pay attention to Felicia Holmes, because you do get an idea of what this investigation is. The fourth witness was Kurt Rhodes, the DNA expert. Now, why is he important? Because while we were picking a jury in April and we were off in May, this prosecutor asked him to go back to the car and check some DNA. Now, why would you do that? The case, according to Moretti, is closed as soon as this young man is arrested. Why do you go back 5 years and ask an expert, a DNA expert, to do some more testing? This kid walked into the Broward, voluntarily surrendered. And 5 years later, they have the audacity to say, do a little more testing. Why? Because now we're in trial. And they realize there's problems with the case. Why else would you do it? Three years after this young man surrenders, they bring in Danny Polo. I call him the masked man. He came in here for a few hours, if you recall, got on this witness stand and wore a ski mask over his entire face where you could only see his eyes. They came in here. He got involved in 2022 at the request, again, of the state, the prosecutor. What was the purpose of that? The great gang expert? They wanted to link him to some gang. You know, in the rap culture, whether you want to accept it or not, gangs are attracted to it. If you want to be successful in rap music, you are going to pick up some of the nuances of various gangs. Snoop Dogg, to this day, it was. Oh, all right.
No problem. Yeah, ladies and gentlemen, this is argument. All right. Proceed, counsel. Judgment is overruled.
Snoop Dogg, to this day, does hand signs of a gang.
I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I'm so high right now, y'all. I'm about to go to sleep on y'all ass.
And he does that because he realizes it promotes his music. That's the bottom line. And because he wants to promote his music, make money, he's all of a sudden this big gang guy. And they wait till 2022 to bring him in. Thought the case was closed, according to Moretti. And they show you some text messages from, I think it was Gino Burke and Wando, who fought with Anthony Williams previously. Now, certainly,
if the investigation is being fair and you want to find who was involved in this case, you would relay that information to the lead detective of people of interest.
Well, isn't this a nice surprise?
All right, hold on. We got a little intermission. We're going to cut to the other part before we finish the rest of that. We about halfway or a little past halfway through with that one. But I got a little something else I want to show y'all. It ain't too, well, it is kind of long. But anyway, we going to get into it. Appreciate y'all being here. Hit that like, hit that subscribe, tap in, share with a friend. Let's get it. Just mix it up a little bit. You know what I'm talking about?
Endless resources to perform their mission of pursuing justice. But that's not what occurred here. What they will bring you is a case that is riddled with reasonable doubt, that is founded on an incompetent and incomplete investigation and the exercise of poor judgment at every turn. The state cannot prove beyond a reasonable doubt the allegations that they have made. And there is a reason for that. You recall Ms. Bradley, some of you may recall, during jury selection, going to great lengths to let you know that she does not have to prove motive. And she's right about that. The law doesn't require her to prove motive. But you know what does require motive? A young man to wake up one day and decide that he's going to kill two of his best friends. Best friends that he grew up with, best friends that he hangs out with, best friends who he lives with, best friends whose careers he was trying to launch alongside his own. They have no reason for why he would do this, because there is no reason. And if there's no reason, it doesn't make sense. And if after 4 years of investigation, the state comes and says, hey, he killed two of his friends, his best friends, and you're wondering why, and their answer is, oh, I don't know. That's the first indication that they're just guessing and don't know what they're talking. And that, ladies and gentlemen, by itself is reasonable doubt. Why he would commit such a heinous crime against his own two best friends for no reason. What happened here is that the lead detective, Detective Moretti, saw a video of Mr. Demons getting into a car 40 plus minutes before bodies were found in that car. And then he discovered that Mr. Demons was a rising star. And from that point on, he decided he's the only person that could have committed this crime. Because if you're involved in prosecuting a star, you become a star. This was his big break. And he had tunnel vision, and he zeroed in on this person, this young man, as the only possible perpetrator of that crime, to the exclusion of all other leads and evidence. There's a difference between cases that are investigated and cases that are fabricated. When a case is investigated, the state uses all its resources, its investigators, its experts, and all its energy to identify leads and run them to ground. When a case is fabricated, first a target is chosen, and then the state uses all its resources, its investigators, its experts, and its energy to run that target into the ground. That's what occurred here, and there's a reason why I say that. There are a number of leads that you will discover that were identified by the officers, but were either completely ignored or given short shrift. I'm going to let you know, run through a few of them by way of example. Start with the most obvious one. Cortlen Henry. Now, Ms. Bradley started her opening statement by describing some of the lies that he told, as though to impute them to Mr. Demons. Those were not Mr. Demons' lies, those were his lies. Cortlen Henry shows up at Memorial Hospital, Miramar. You don't see him sitting there, but where you will see him sitting is in the driver's seat of a car with 2 dead bodies, car riddled with bullets. And when he shows up with a change of clothing, change of shirt.
Okay, now y'all know that raises the question, right? Everybody talking about these snitching allegations with Young Thug and all that, and all this snitching. Is this considered snitching by him pointing at Cortlen Henry and saying that he's the one that did this and that and this and that, pointing the finger at him? You gonna let your lawyer point at him, or are you supposed to say, don't say nothing about him, or else I'm gonna be looked at as a snitch?
Gunpowder residue on his hands, evidencing that he had discharged a firearm. And he lies. He lies about where the incident occurred. He lies about how it occurred. And he lies about not having a phone. I think it was Miss Bradley herself who said, everybody has a phone in his pocket, not Cortlen Henry. There were 3 phones in that car. There were 3 people in that car. So they take him at his word, despite suspicious circumstances, and they let him go on his way. They soon discover that he's lying about the location of this incident, and they went back to him, and they labeled him a victim. And they said, we know you're scared. Tell us what happened. He lies to them again. They let him go. And they know where he went.
A victim. They said that earlier. Remember, he was a victim at first. No fingerprints, none of that. On no weapons or none of that. He was a victim, considered according to them.
They know the location that he went. They know the house that he went to right after. And any investigator worth his salt would have thought to maybe execute a search warrant on that location to see if you find any bloody clothes, any DNA, any blood. A weapon, maybe? You guys are probably familiar with the series First 48. That's founded on the proposition that if you botch an investigation within the first 48 hours, you pretty much botched it for good. It's 48 months plus later. They still haven't served a search warrant on that location. Why? Moretti already had his man. What's the point of an investigation? To find out what happened. He's using all his resources to try and prove what he has already concluded did happen. So, after Cortlen Henry, lead number 2, a gentleman named Montrell Roll, and his sister, Nia Hewitt. Who were they? Well, another police department came into possession of jail calls between those two that occurred within 3 days after the murders, and discussed what they describe as intimate details of the murders. Intimate details means details that are not in the public domain. So 3 days after, these two people are discussing the details of a murder. They go out and interview Miss Hewitt. They don't interview Mr. Roll.
That wasn't me, but that was on point, though.
They go out and interview Miss Hewitt. They don't interview Mr. Roll. And they ask her, well, how did you know all these intimate details? Oh, I heard it, something to the effect of I heard word on the street. Doesn't say when she heard it. Doesn't say who she heard it from. Case closed. They move on. That's lead number 2. That was ignored. Then there's Robert Colbert. Who is he? He is a gentleman that owns a social media account by the name of Backwards. This social media account, almost immediately, within days after these murders, posts this message: LOL, we killed 2 of your niggas. Oh, really? Took him 7 months to go and talk to Mr. Colbert, the owner of this account, that posts what amounts to an unequivocal confession to involvement in that murder, in those murders. 7 months. Why? Moretti already had his guy. And when they go and talk to Mr. Colburn, what does he say? He said, oh, I created that account and I sold it for $20 to somebody else. Who'd you sell it to? Oh, I can't remember. Were you at the murder scene? No. Did you do it? No. Case closed. That's it. No more investigation. It would occur to a reasonable person, let alone a seasoned investigator acting in good faith. Why would somebody buy an Instagram account when you can create one for free on your own? If not to hide your identity. And if somebody goes to the trouble of buying an Instagram account to hide their identity and then confesses to a murder that you're investigating, maybe you ought to go and figure out who that person is and talk to them. And maybe there is no such person. Maybe it was not sold. Why would somebody create an Instagram account and sell it for $20? And if he's in the business of doing that, that's of interest. And how would anybody know to go to him to buy an Instagram account? These are all unanswered questions. No investigation. Case closed. Let's move on. David Hedgepath. Who is he, you might wonder? He had a Twitter account called Crucial Almighty. He posts a confession to this murder. Something to the effect of, we coming at that Jeep. Can't remember the quote. You're going to hear about it. And essentially it was a confession to involvement in the murders. It took them 1.5 years to go and talk to him. They knew about it 1.5 years earlier. It took them 1.5 years to go and talk to him. Why do you do that unless you've already concluded that you know who committed the crime, you've already determined who your defendant will be? And when they go to this young man and ask him, well, actually before, this is 1.5 years before, they said, oh, we've determined that he was just trying to start an internet beef to advance his career. Who told him that? Without talking to a soul. So it took them 1.5 years to go down there and track him down. And when they do go and track him down, they say, hey, did you commit the murder? No. Were you in the area? No. Where were you? Well, I could have been at work. At work where? Any one of 3 places. Okay, could you give me your work schedule? As though that would prove anything. He said, well, I can get it now. Oh, no, don't worry about it. Just email it to me. Really? And he doesn't even do that. There is no report that he even follows up and sends them an email of this mysterious work schedule proving that he wasn't at the location. They conclude, oh, he's not there, wasn't him, case closed. Is that how we do this now? That's not all. There are several other people who are potential suspects who were not tracked down. You are going to hear about them during the course of this trial. But beyond that, 3 years after arresting this young man and sticking him in a cell, the state looks at its case and says, oh man, this looks a little incompetent. Miramar Police seems to have botched this investigation, and they call the Broward Sheriff's Office and ask them to come and look at the investigation upon which this entire prosecution rests. And he looks at it, and he says he instantly knew he had to start from scratch. I think his words were, "It was the worst thing I had seen in my life." This is the Broward Sheriff's Office evaluating the work.
So YNW Melly was arrested February 13th, 2019.
Product of the Miramar Police Department. And we have problems with the Broward Sheriff's Office redo as well, but you're going to hear about that during the course of this trial. Ladies and gentlemen, the murder of anybody and the murder of these two young men was a tragedy. You're not here to solve a crime. That's their job, and they have watched it. Jurors often get confused as to their mission. You can't do a job unless you know what that job is. Every civil society needs to have a prosecutorial arm prosecuting crimes and offenses. That's a noble pursuit. There's nothing wrong with that. And every country does it. In some countries, the prosecutor decides who the person is, they send a cop to go arrest him, they throw him in jail, that's the end of it. We don't do that in this country. What we do is we ask, are you sure about what you're talking about? That's the purpose of this proceeding. You're not here to judge Mr. Demons. You're here to judge the sufficiency of the state's case. That is your assignment. You're not here for a show to see who you like more. There are two grades, beyond a reasonable doubt and not guilty. A+, everything else is an F. There's no A's, there's no A minuses. You are akin to an FDA lab. Imagine a company saying, we're going to put on the market fat-free milk. And the lab, their mission is to determine whether or not there is fat in the milk. And what do they look for? They don't look for milk. They look for fat. The state is telling you they have a state that is free of reasonable doubt. You're not here looking for proof. You're here looking for doubt. And if you're off looking for the wrong thing, you're going to miss what you are here to look for. They have no motive. Their entire case is hinged upon the technology of a phone they claim to have been in Mr. DeMons' possession. What they fail to tell you is that they have come across evidence that Mr. DeMons got out of that car before this incident. They ignore that because it's not consistent with their theory. What they fail to tell you is that phone comes back to the name of somebody other than Jamal DeMons. What they forgot to tell you is that their own witness will tell you that yes, that phone and Mr. Williams' phone and a number of other phones were all in the same account, and all of the people in the house used to use them interchangeably. But they're assigning it to him because that is consistent with their theories. They don't follow leads. They have no motive. Investigation was botched.
Monkey shit.
The investigation, as a matter of fact, is still going on as we speak, up to a couple months ago. Yet they're here telling you they have proof beyond reasonable doubt. And what you're still investigating for. The job of the state is to prove it beyond and to the exclusion of every reasonable doubt. And if you're a reasonable person and you have doubt, that's reasonable doubt. There's a song called Things That Make You Go, hmm. If you say, hmm, that's reasonable doubt. You do not. Ms. Bradley is charming. She's good at her job in some respects. But this is not a popularity contest. We don't give, hey, good effort. We don't give participation awards. This man's life is hanging in the balance. And if there is a scintilla of reasonable doubt, you must have the courage to speak up and say so. You're not here to judge him. You're here to judge the sufficiency of your case.
The absence of evidence is not the evidence of absence.
What?
Big facts, big facts. Big facts, big facts. The burden of proof is on the prosecution. They must prove beyond a reasonable doubt that he is guilty. They are guilty, both of them or whatnot. They can't say, oh, they might have did this, they might have did that. No, mights don't count. Y'all talking about taking his life. Y'all got him up for the death penalty. You cannot have any type of doubts. And y'all been here for what, 6-7 years? Since 2019, February 2019, he been in jail, and y'all still ain't proved nothing? That's insane. How could it take that long to prove something? If you got the case, then prove the case. Why y'all playing with this boy's life? All right, we gonna finish up. We got about a little bit more. We was about halfway through. Let me see. I'm gonna put him on a little speeder up. I didn't realize he was running regular too, so it'll go a little faster. But yeah, appreciate y'all. Shout out to our stream sponsor, Chan My Black is Golden. Let's keep it rolling.
Or suspects. And what do we find out? Moretti has no idea who Gino is, no idea who Herc is, and doesn't know about Quando Wando. This is the great investigation. But he also refers to some text messages where those individuals that are in fact associated with the gang text him and he's not responding. And to the point of not responding, they say they're going to put you on the plate. Now that's not for dinner. That's not for breakfast. We learned what that means. If you don't start responding to us, we're going to have you killed. What the heck's going on? Why wouldn't you investigate this? They want you to believe that there's no evidence of that. How do they know there's no evidence if they don't investigate? They don't search. They don't look. You've got all these phones. Get Gino and Herc. You have their text messages. Go get their phones, track them, and see. We don't have to do a thing, folks. The presumption of innocence stays with us during the entire trial until and if they can prove beyond every reasonable doubt that this young man did anything wrong. Moretti didn't want to look at that. Why? Because God forbid they find some evidence. His arrest of a star is down the tubes. That's the bottom line. I want you to pay particular attention to Dr. McDougall and Dr. Saunders. Because those two doctors, one being the chief medical examiner of Broward County, the other one an associate medical examiner, I think now employed in West Palm Beach, say to you that the first shot to Williams and Thomas were fatal, deadly. Why is that important? Because according to Sergeant Williams, Thomas's injury to his hand came first. It was a defensive wound. We know that couldn't happen based upon the medical testimony. So you either have to disregard the medical examiner and accept what Williams' testimony is, or I suggest, now that you have 4 experts contradicting Williams' testimony, and that is Bellow, Special Agent FBI Agent Collins, and 2 medical examiners, conflict with Williams' testimony, that you should take Williams' testimony and ignore it, toss it out. You can't have it both ways. It just doesn't work. And then we get to really their star witness, 2 star witnesses. Sergeant Williams. I think I've talked a bit about him. And I think the most amazing part of his testimony is that he does not get involved in this case until 3 years after the incident. Again, at the request of the state. Again, because they realize they have problems. And I applaud them to recognize they have problems. And miraculously, as I told you earlier, even though the Jeep was searched for hours and hours, processed for hours and hours, he finds additional evidence. 2 projectiles that everyone else missed, and a blood stain that is important. And that when he did his analysis, 2 important things occurred. He didn't go in there blindly to do any analysis. He told you that the prosecutors in this case told them that the defendant in this case was this young man. And we need you to do a trajectory analysis to put him on the scene. Now, I suggest to you, you could have a Jolly Green Giant and a midget, and if you give them the dimensions, the height and his arm length, with this mathematical formula, you could say the Jolly Green Giant or the midget was a shooter in this case. They would either be closer to the car or further from the car, depending upon their size. If you want to do an analysis, if you want to do an investigation, if you want to figure out who the shooter is, why do you point to this kid and tell him, this is what we want? Why do you do that? This is the great investigation? This is what they want you to do in order to render a verdict that could take him? And tell him that he's going to live life in the state penitentiary without parole or be on death row? This is the investigation they want you to rely upon and say it's proof beyond and to the exclusion of every reasonable doubt? I guess so, according to them. And they call Danny Benitez. Who the heck is he? He was on the stand for all of about 2 minutes. Danny Benitez gave Detective Moretti the surveillance tape from the Montessori school. You watched it. It showed, I suggest, nothing probative to implicate this young man in it. But we learned, not from him, but from Moretti, that he doesn't go to the drugstore on Miramar Parkway to check their surveillance tape. He doesn't go to Applebee's to check their surveillance tape. He doesn't go to Polo Tropical or the gas station or the bank on Miramar Parkway to check their surveillance tapes. When the car's on 184th Avenue, he doesn't go to the fire station to check their tapes, surveillance tapes. Doesn't go back to the two elementary schools, Sunset Lakes and West Broward Elementary, to check their surveillance tape, because he knows it all. He knows it. How do you know it if you don't check it? How do you know something unless you investigate? We don't have to do a thing, folks. We don't have to do anything except show up. And begrudgingly, we did. Where the Montessori school was, on Pines, there was a tractor supply company and another school.
The reason is because someone on his legal team is also under criminal investigation by these same prosecutors, which he says is a conflict of interest. He is replacing them with a well-known hip-hop criminal defense attorney who YNW Melly is changing lawyers amid his murder case that is scheduled for retrial in 2027. The reason is because someone on his legal team is also under criminal investigation by these same prosecutors, which he says is a conflict of interest. He is replacing them with a well-known hip-hop criminal defense attorney who previously represented Cardi B and Lil Nas X. Melly is charged with 2 counts of first-degree murder in connection with murders of his 2 childhood friends. His first trial on the murder charges ended with a hung jury in 2023. He faces the death penalty if convicted.
Well, isn't this a nice surprise?
Why don't you get that? And come in here and say, you know what, folks? We checked all of this. Instead, what they do is take a helicopter ride 4 or 5 years later. And we have to sit here and watch as they fly the route. And we have to watch how they drive the route. Not checking what the traffic conditions were that day, back 4 or 5 years ago. Not checking what the weather was 5 years ago in October 26th. What's the purpose of that? Just to add more of what I suggest is a smoke screen. You look at all this and say, heck, man, 100 exhibits, 500 photographs out of a cell phone, all these text messages. What does it mean? Hopefully, for the state, you'll say, hey, where there's smoke, there must be fire. And say, hey, too bad, young man, too bad. There's a lot of stuff sitting here. And hopefully you will not fall into that trap. And then we get to the lead detective. Well, before we get to the lead detective, I think I missed someone. Trevion Glass, the individual who got into the red Mitsubishi. The man who is convicted of 2 felonies. Now, why is that important? Because the judge read you an instruction on some of the factors to look at in determining whether or not to believe a witness or not. And he told you that one of the factors to look at is whether or not the witness has been convicted of a crime. Trevion Glass, the state calls, as their star witness, basically, to say Melly never got into that red Mitsubishi. And he told you one interesting thing. He said he's got a case pending right now, and he doesn't want to go back to jail. Now, who has the authority to put him in jail? We don't. There's only one person who can put him back in jail. And that's the state of Florida, whether it be through the state attorney's office or the police department. And he miraculously is the only witness that says no one got into the red Mitsubishi from the recording studio. But he tells you, doesn't tell you how he gets into Melly's house. Because he doesn't have a key. So, what's going on here? What's the story here? And then they call their star witness, the lead detective, Detective Moretti. We know he doesn't look at the surveillance tapes on the various Miramar Parkway and Pines and what have you, because he knows. He's worked the area. He knows that he got 9807, the phone that Melly has used, and you've seen various and a lot of photographs. I think it's Exhibit 115, am I correct? 100, excuse me, 100. And who did they get this phone from? Detective Moretti? Jameson Francois. And certainly you ask him, how long have you had this phone? And he says, I never asked him. How convenient. And he goes and says there was another phone in the vehicle, but it was broken. That's 115? 115. So I can't tell you whose phone that is. Now, we don't have a burden to do anything. If you recall, we asked him to take out the SIM card of this broken phone. And there was a reason for it, to tell you the quality of the investigation. He took out that SIM card, read the serial number from that SIM card, which he had never done until you saw him open his phone in the courtroom. And he agreed that you can take that serial number to T-Mobile, Sprint, and what have you, and determine whose phone is, who is the owner, subscriber, and get a warrant for that phone. You've got warrants on a lot of phones. Get a warrant on this phone if you want to see what it is. Moretti doesn't want to do that because he's afraid. It'll ruin the investigation. That's why I put these two phones separate and apart from all this other stuff. Now, the state said to you, there was no reason, I think was the exact quote, for the Jeep to stop on the side of the road. I suggest to you that as we have done periodically through this case, the reason was
Again, ladies and gentlemen, this is argument. Proceed, counsel.
the reason was because you needed a bathroom break, just like you and I did when I raised my hand or stand up. And at 3 o'clock in the morning, 4 o'clock in the morning, if he needed a bathroom break, in the dark highway, and you saw him carry it in his hand, he'd leave it on the seat of the car. And we know that the car sped off because there was another car waiting, the red Mitsubishi. You want to know there's no reason? The poor kid had to urinate. And the phone was in the car. But they don't want you to know any of this. That's why we had to call Adrian Davis. But let's stay on Moretti for a little while. Because they execute a search warrant on his house, his apartment, and his storage unit.
Yo, I'm looking for Christine Bradley testimony. I want to bring some of that in, Christine Bradley. And it was another lady who testified and said Christine Bradley had messed up too. I want to play a little clips of those. If anybody got them, let me know. I'm looking for them. No, keep it rolling, family. Appreciate y'all.
They find ammunition in there. They find in the storage unit, I think, 3 holsters and gun locks. We don't know what type of guns belong to those holsters. We don't know what type of guns were the gun locks to. All we know is there are 3 guns missing based upon the 3 holsters. And Moretti doesn't even ask where these weapons are. What are these weapons? Should it concern you? Yes. Should it show you a lack of evidence? Yes. Ask yourself. They keep telling you to use your common sense. Use your common sense, please. Ask yourself why a lead detective of a double homicide would not ask Jameson Francois, where the hell are the guns? Where the hell are the locks that belong to the gun? Where are they? I suggest to you when you use your common sense, you're going to say, he doesn't want to know. Because, God forbid, those, or one of those, could be the murder weapon. And then, the investigation of this rap star is down the tubes.
It's crazy, fam. They can hide some stuff they don't want you to see. I see people talking about it. I see some of the clips, but where is the full thing?
He reads to you various messages from various people. But he never goes to talk to these people to see what they meant.
Actually, I played it before. I might have it in my files. Let me check my files.
You search Jameson Francois' car that supposedly is involved in taking Melly. And 4 months later. Well, if you go and search his car, Jameson Francois, let's go back again to his house. Get up here, State, and tell why you didn't search the house. You learn about Frito Bang, supposedly. Supposedly takes him somewhere. Why in the heck don't you search his house? Even if it's 4 months later, 5 months later, 10 months later, and use that fancy spray. Not the one that causes you to get sick, but the new spray. And look for it. What kind of investigation is this when we're talking about putting a young kid on death row or life without parole? Or any investigation? This is no game, folks. We're playing for all the marbles. That's why they said that Miramar Police Department lacks the training. They did absolutely nothing once they got that surveillance tape. Blinders. Blinders on them. We're not going to look to the left. We're not going to look to the right. We're just going to direct everything to this young man. And I'm glad they admitted the suspects of 13. We know that Cortlen Henry's involved. You heard about Crucial Almighty David Hedgepath, who wrote and texted, "We killed 2 of you." And someone said I should use the word ninjas instead of the word that he used. And in that message, he had a target over someone's face. Whose was it? Guess what? It's Melly. And he did it within hours. And what did they do? Nothing. Years later, they get his so-called timesheet where he was working. They don't bother to talk to any of his co-employees to verify this. In fact, if you look at the timesheets, it gives him time to, I think he's up in Verrill and Melbourne, to be exactly in Broward County, which is about 2 to 3 hours before the job. It's no alibi at all. But why don't you talk to these people? Why don't you investigate? How in the hell does he...
Someone said I should say ninjas instead of the other word. Who the hell told you that? The hell, Bobby? Let me see. This is the only one I can find. This is as close as I could get. Let me see if we can get a little bit of it. I ain't listened to it yet.
Assistant State Attorney Michelle Boudreaux, who was a witness to the incident, testified in a hearing last week that she overheard Moretti ask a deputy to lie about being present during the phone seizure.
Detective Moretti said to Deputy Morrell, "You need to say you were here when I served that search warrant." And it was kind of like an awkward moment. Someone described it just kind of getting punched twice in the head. So there's a search warrant that gets served, and I'm like, what's going on? And then the next thing, he's asking this deputy to lie for him. And again, I'm like this is like, I'm in the twilight, so I'm like, this can't really be happening. Deputy Gorell didn't say anything of any substance. I think he said, "Is there anything I'm needed for anymore?" or something like that. I don't remember if he said anything at all. It was just a very awkward moment.
Do you say anything to Moretti?
No, I don't say anything to Moretti. I leave the room, I'm done with the statement. As far as I'm concerned, I'm done investigating this case.
Why?
Because I don't work with detectives that solicit lies.
Boudreaux said she reported the incident to her direct supervisors and prosecutor Christine Bradley, who testified in the hearing defending Moretti's actions, saying the whole thing was a joke.
Is that true that Detective Moretti said to you that what he said was a joke?
No, what was intended to be conveyed was that Deputy Gorell, his response was flippant in nature. That was the joking aspect of it.
Okay, so if somebody from your office sends out a Brady notice in this case, not authorized by you, correct?
That is correct.
And in that Brady notice that I just showed you, you're saying that there are incorrect statements of fact.
That is correct.
And the incorrect statement is that you were not told.
So they got caught with Brady evidence too, family. Brady evidence too.
By Moretti that he was joking.
That is correct. The indication has always been, and if it was inartfully conveyed in some point, the indication has always been that Deputy Gorell responded in a very flippant manner when asked about showing up.
Flippant manner
to Detective Moretti.
Does he say that in his report, Gorell?
I don't believe so.
Okay.
The truth is, you are a liar.
Flippant matter came from Moretti, and somehow you communicated that Moretti said it was a joke. Is that what we're putting together?
I did not say that Moretti said that he had made a joke in any way, shape, or form.
So you've never made the statement that Moretti said he was joking?
My statement was, at all times, and if it was ever not clear or misinterpreted by whoever was listening to it, was that Deputy Gorell made the statement that was of a flippant nature.
On August 30th, 2022, Christine Bradley filed a Brady notice, which requires prosecutors, Melly's first trial.
You sat through the trial. Nothing was mentioned about Brady. We find it hard to believe that nobody, whenever that was, Miss Bradley, to file the Brady notice. And this goes back as early as basically in October, November, whenever that was, of 2022. The testimony will show that after they did that, pretty much everybody put their head in the sand. They did not check into things. She went through a whole trial. She sat through the trial. Nothing was mentioned about Brady. We find it hard to believe that nobody would have asked her even after the hung jury. Well, how did you handle that Brady issue?
And according to the defense, after Boudreaux brought it
Crazy, family.
Bradley refused to sign the Brady notice that was prepared by the supervisors in the office, and she refused to sign it. In fact, that Ms. Bradley refused to sign the Brady notice that was prepared by the supervisors in the office, and she refused to sign it. In fact, it was handed to her by her secretary, and she said, "I'm not signing this." And that's why Mr. Killeran from Public Corruptions had to sign that Brady notice.
Once Melly's defense team contacted Boudreaux,
Now, ain't that some crazy, ain't it, family? Crazy stuff, crazy stuff.
He get
We almost up out of here, family. Stay with us.
send out a text. We killed 2 of you. We were aiming at the Jeep. Bentley, who had a problem with Mel. He does nothing. That's not a person of interest. He knows that there is a incident at Walmart where he's robbed of a chain, I think it is. Why don't you get this surveillance tape? Or at least try so you can say, I tried, and it doesn't exist anymore. Jameson Francois with the missing guns. He's the manager who had, I think, $16 million in his account. If anyone had a motive, in this case, it would be Jameson Francois, possibly. I don't know. We don't have to prove a darn thing. Why don't you at least investigate? Why don't you do the work that is required before you ask 12 of you to either put him on death row or life in prison? Jay Green, who had a beef with Melly. Why don't you check him out? Quando Wando, why don't you check him out? Gina, who said he's going to be on a plate. They're going to kill him. Moretti says, I don't even know who the heck Gino is because no one told me. Herc says you got to communicate with us or you're going to pay the consequences. He doesn't know who Herc is. Goon. Same thing. And then the state rests. They say, folks, we've presented you all the evidence. Well, that wasn't true. Because we had to call Adrian Davis. And you learned that Adrian Davis showed up in the state attorney's office and gave a sworn statement. They never told you this. We did. We don't have to do any of this. And Adrian Davis said, I told you. He got in the car. How do I know that? Because I was woken up when someone was crawling in the back seat. How do I know that? When we got to Melly's house, he's the one who had to open the door. Because only he and Cortlen Henry had the key to his house. Why do we have to do that? Why did they conceal that from you? Why did they hide that from you? I can't answer those questions, folks, but I don't have to. Other than to say, reasonable doubt. You know, when we started this journey together, the state promised you that they were going to prove their case beyond to the exclusion of every reasonable doubt. They told you that they have accepted the responsibility
that they have the burden of proof. They told you that they would prove each element of this case. What they have proved to you is that Cortlen Henry is involved in this case. Who else, if anyone else, you folks don't know from the evidence. They tell you and play you a video where Melly appears in Cocoa Beach that afternoon. Well, as AD told you, there was a contract, and people were going to lose a lot of money. And he happens to be at the tender age at that time of 19, a professional. And we all know, and unfortunately, probably a lot of us have had to do something while we are suffering an illness or a death in our family. What does that prove? Absolutely nothing. Other than at the tender age of 19, this kid, I say kid, I shouldn't say that, this man, young adult, is a professional. They say because he didn't show up at 1 or 2 jobs, then what the heck? They have no idea what the contract was. They have no idea how much money was involved. They have absolutely no idea. Why? Because there was no investigation. Play this. And they want you to believe that he's a cold-hearted murderer. When quite to the contrary. You saw the tapes. You saw that he's a nice young man and a professional. Folks, the worst thing any lawyer can do is sit and see a misjustice, no matter what side of the fence you're on. Especially when you're talking about a 19, now 23, 24-year-old kid. Man, young adult. To me, he's a kid. Because I have children older than him. The worst thing you can do is sit and see a misjustice. And we have sat here for months, starting in April, waiting to see the evidence. And I suggest to you right now, you should have more questions than when you were selected as jurors as to what really happened.
Shout out to his moms, man. Gotta sit there and go through all this while they sitting here playing with this boy life. Ain't got no evidence, no proof, nothing, but gonna keep him in there for 6+ years before they even start the trial. I mean, you know, officially, since the other one was a mistrial. It's crazy, and she gotta sit there through all this. That's insane.
And there was a gentleman who recently said that our system of justice is broken. I don't believe that. But he got on TV and it was all over national news saying, I think our system of justice is broken. If you want to do justice in this case, and you want to follow His Honor's instructions,
Lady Justice is blind. Everybody can hear.
prove their case beyond and to the exclusion of every reasonable doubt. You will go to the verdict form and check off count 1. We, the jury, find as follows to the defendant. Not guilty. We, the jury, on count 2, find the defendant not guilty. You may think he might be involved. That's not enough. It's waver and vacillate. That's what reasonable doubt is all about. You want to make sure the justice system stays intact.
There is only one just verdict based upon the evidence they presented. And that is, state, we just can't rely upon this beyond to the exclusion of every reasonable doubt, because there is a lack of evidence, there is a conflict in the evidence, and the evidence itself, and the investigation itself, stinks. I'd use another word, but I would probably get held in contempt. But I think you know what it is. So say we all.
Slap.
Bars. He was dropping them bars. Dropping them bars.
Which is case number 23-10643 CF10A. You're charged as follows. Count 1 is tampering with a witness in a capital felony. That is punishable by life in Florida State.
Oh shit. Hey, my bad.
There is also life in Florida State Prison. Count 5 is
My fault, y'all. My fault. I'm tripping. I did the wrong thing. I'm highlighting the wrong stuff. We gonna end it out with this with this verdict. I mean with this plea deal they trying to offer him. Hey, don't plea deals usually be offered behind the scenes too? That's crazy. They did it in front of everybody. But my bad. I turned up the wrong sound like a mug. I got you, family.
which is case number 23-10643 CF10A. You're charged as follows. Count 1 is tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. All right? As the maximum penalty. Count 2 is directing the activities of a criminal gang. That's a first-degree felony punishable by life. So the maximum penalty there is also life in Florida State Prison. Count 5 is conspiracy to commit tampering. And again, as it's charged, that is also a life felony. The maximum penalty is life in Florida State Prison. And lastly, count 7 is unlawful use of a two-way communication device. As that's charged, the second-degree felony. The maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing,
you're really only facing the charge for having a cell phone, which is 15 years, for having a phone in prison. The hell, Bobby?
The maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison. Do you understand the charges and the maximum possible penalties involved? Okay. So, Mr. Henry, the state is telling me that they're extending an offer to you, and the offer is as follows. In case number 19-1871 CF10A, they're going to null process or drop counts 1 and 2, both first-degree murder.
You drove my wheels.
And in exchange for that, as to counts 3 and 4, in that case, the accessory after the fact to murder in the first degree, you're going to plead no contest to both of those. And as to the 4 counts in case number 23-10643 CF10A, you're going to plead no contest to all 4 of those counts. And in exchange for all of that, the state is offering that I would adjudicate you guilty and sentence you to the bottom of your sentencing guidelines, which is 195.45 months, about 16, it's a shade over 16 years and 3 months. So you can sentence you to all 4 of those. And in exchange for that, as to counts 3 and 4, in that case, the accessory after the fact to murder in the first degree, you're going to plead.
Hold on. We wrapping it up, family, but hold on. I need y'all to catch that and listen to that. So exchange for them 5 life sentences plus 16 years, in exchange for you taking this plea and copping out instead of going to trial, we're going to give you 16 years. and just call it even. We just gonna call it even. We ain't got no evidence you did nothing. We gonna drop the murders, even though the murders is the charge that creates all the rest of the charges. But you wanted me to bring you gonna drop those charges. But if I don't take the plea, then you gonna hit me with the murder and accessory to murder. Wait, what? How? What the hell? The hell, Bobby? I'm confused. That's insane. What is wrong with these people, man?
No contest to both of those. And as to the 4 counts in case number 2310643 CF10A, you're going to plead no contest to all 4 of those counts. And in exchange for all of that, the state is offering that I would adjudicate you guilty and sentence you to the bottom of your sentencing guidelines, which is 195.45 months, about 16, it's a shade over 16 years and 3 months. 16 years and 3 months. All of those sentences will run concurrently, that is at the same time with each other. I would give you credit for all the time that you have served, understanding that you have a lot less credit time on the 23 case because it's a newer case. So that is what would be controlling. Whatever credit time you have on the 23 case, you could subtract that from the 100
I think he actually has more time on the 23 case than the 19 because he's out of custody.
Oh, okay. Well, whichever case you have more time, less time in custody, that's what would happen. And you get the credit for all the time that you've served. And again, that sentence would be 16 years, a shade over 16 years, 3 months in Florida State Prison. I would have to order restitution. The state would tell me the amount of that restitution. That restitution would be joint and several with any of your other co-defendants. If any of the other co-defendants were convicted at trial or entered pleas. In other words, the restitution only has to be paid once, but each person is responsible for 100% of it. All right, but as soon as it's paid, it's paid. I would have to impose mandatory court costs in each case, and I would have to impose a mandatory cost of prosecution in each case, which is $100. So, Mr. Henry, do you understand the offer that the state is making to you? Okay, the 16 years, 3 months, and a shade more. So I'm going to pause on it at this point, Mr. Henry. It's going to give you some time, whether that be tonight or also over the weekend, to talk to your lawyers about it. Make sure they answer all your questions, talk to your family about it so you can make a decision as to what you want to do. Now, let me explain this to you, sir.
The absence of evidence is not the evidence of absence.
What?
Talk about hell on earth, family. We living in it, right in the midst of it. Ain't no way they should be able to get away with this stuff they doing. And then they sit there and do way worse than any of us are doing, and they don't get no charges. They don't have no problems. Even the cops, they go out there, even the cops is out there killing people without no type of justification, no type of penalties, no nothing. Just crazy, man. I don't even know. My brain is hurting from seeing this stuff. Shout out to Mary W. I see you. Appreciate you, family. Shout out to No One in the chat. No One. Monkey shit. That was a whole lot of
monkey shit.
That's a fact. Chan My Black is golden. Shout out to the Queen. Appreciate you. Shout out to Chan My Black is golden. Much love, much love. Miss D56, what up, what up? I see you. Shout out to Miss D56. Much love, much love. Late night baking with Mookie in the house. Got the new emoji on deck. Yeah. Had to upgrade it. You know what I'm saying? Time for an upgrade. I kind of got tired of seeing that Eminem. I ain't gonna lie. It was making me feel, anyway, kind of suspicious. Nah, I'm just playing. Shout out to Aaron. Aaron Adventuring. What up, though? I see you. Appreciate you. Joni Ford. Appreciate you. Shout out to Joni Ford in the building. Starfish and Coffee in the building. Shout out to Starfish and Coffee. Much love, much love. Cynthia Trop. I got it right that time, I think, right? Cynthia Trop. I got it right that time. Shout out to Cynthia. Shay in the house. Allie in the house. What up, Allie? What up, Shay? Appreciate y'all. Brown Sugar Babe. Brown Sugar Babe got the new emoji in the house. Appreciate you. Shout out to Brown Sugar Babe. Got the new emoji on deck. Other than that, man, shout out. Oh yeah, Tat Clouds came through early. Tat. Shout out to Tat. Much love, much love. And other than that, man, I had a good time hanging out with y'all. So I will be going tomorrow. They should be airing tomorrow morning. We should be live. So I'll hop on in the morning. And hopefully we can stream it live. You know what I'm talking about? If they ain't doing too many games. You know how they be playing them games sometimes. So ain't no telling. But other than that, family, you know what it is. Appreciate y'all. Stay fresh. Stay blessed. And peace out.
Have a good night. Have a good night. Have a motherfucking good ass night.
Peace, love, and joy, Joni 4.